For troubling one matter, yes, my lord, one matter, which is item number 5.
Yes,
My lord, this matter substantially it was heard by the another bench,
okay.
which is now being court number 2. Is about only compliance of two particular the documents. About 19 pages, the order was passed, and there is some one correction of the order. So invariably, if it goes before that bench, I think your lordship may not be like to correct the order also.
Okay.
There is some wrong.
There is some rectification required.
Yes, also required in the order. That's the reason. So
Okay.
either today or tomorrow, whichever is convenient, I'll not, because it has to, I don't know, maybe in court number 2, other matters are also there.
Let it be, if not inconvenient, tomorrow.
Tomorrow.
Heard Mr. D. Das, Leonard Singh. Oh, Mr.
My
Zimomi,
language
you
is-
have any objection?
No, Lordship.
Leonard Senior Counsel
What?
appearing for the
Other part.
petitioner, also heard Mr. V. Zimomi, Leonard Public Prosecutor. It is submitted by the Leonard Senior Counsel that this matter was substantially heard by a coordinate bench of this court, within bracket, Honorable Mr. Justice A. M. Kalita, bracket close. He further submits that some minor rectifications, typographical
No, terms, factual part.
rectification may be required in the interim order passed by the said bench. Hence, he submits that it may be convenient that if the matter is taken up by the same bench, as the bench is available presently in the Kohima bench, the prayer is not opposed to by the learned public prosecutor, hence same is allowed. Let this matter be listed before the bench of Honorable Mr. Justice A.K. Kalita tomorrow, that is on 7th of August 2026.
May I please, Lordship. My lord, I beg to mention item number 19. My lord, here I'm appearing for response number 1. I'm yet to file my Wagalan and the affidavit. So my lord, kindly allow me 2 weeks time to file this.
And Mr. E. Tiba from Learned Counsel, who submits that he would be appearing for respondent number 1. You have filed Wakalat number,
Not yet.
and he would be filing his Wakalat number shortly, and prays for listing this matter on some other day. The prayer is not opposed to by Learned Counsel for the petitioner, Miss Renboni. Hence, same is allowed. Let this matter be listed
After 2 weeks.
After 2 weeks, on a date to be fixed by registry.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 3 and 4, Your Lordship. Lordship, I have taken the consent of the other side. So kindly list this matter on 20 August 2026.
And Mr. Thuye Krulu, Learned Counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. The prayer is not opposed to by Learned Public Prosecutor Nagaland, and same is allowed. Let this matter be listed on 28th of this of August 2026.
Lordship, here's interim.
The interim order shall continue till next day.
Please, Lordship, I beg to mention item 22 in the supplementary cost list.
22 is tagged with 21.
21, the analogous matters, Lordship. Lordship, the arguing counsel have some personal difficulties today, so.
You are for the petitioner.
And for the petitioner in item 22, criminal petition 7 of 2026.
What is your name?
Rovimeno.
Heard Ms. Rovi Menu Tho, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner.
Lordship, if this matter can be listed on the 11th August, Tuesday.
The prayer is not opposed to by learned public prosecutor, hence same is allowed. Let this matter be listed on 11th of August 2026.
Interim may be
The
continued. Lordship.
interim order shall continue till next day.
Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 17.
17,
Yes, Your Lordship.
yes.
Your Lordship, we are yet to file our affidavit. So I pray that I may be granted 3 weeks to file affidavit.
Affidavit
Affidavit
in
in reply, Your Lordship.
reply. Heard Miss, what is your name?
Sigmo.
Sigmo, learned counsel for the petitioner. Also Miss V. Sukri, learned additional AG appearing for
Respondent number 3 and 10.
respondent number 3 and 10, as well as Mr. A. Angami,
For respondent number 1.
learned senior government counsel appearing for respondent number 1. Learned counsel for the petitioner prays for some time for filing affidavit in reply to the affidavit in opposition filed by the respondents in this case. The prayer is not opposed to by the learned counsel for the respondents, hence same is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry.
Much
Much of that, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 10 to 15, Lordship. Lordship, here I'm yet to file my counter affidavit, so Lordship, kindly grant me 2 weeks' time, Lordship.
What is your name?
Mr. Kachishi, Lordship.
Heard Mr. Misuka Chishi, learned counsel for the respondent, who prays for some time for filing his affidavit in filing affidavit in opposition in these cases. The learned counsel for the petitioner does not raise any objection to the same.
May I please, Your Lordship? If a shorter time can be granted to them, because they've been seeking time for the process.
Suggested date. Suggest
Maximum a week.
Lordship, after 2 weeks, Lordship, since I'm yet to receive instruction.
the
Lordship.
prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Obliged, Lordship.
May it please your lordship. Lordship, I beg to mention item 20. Lordship, here I have instructions to appear for respondents 1, 2, and 3. We'll be filing our vakalatnama within a week. If 2 weeks may be granted.
Heard Mr.
No, sir, on behalf of respondent 1, 2, and 3.
What is your name?
No, sir, on behalf of respondents 1, 2, and 3.
1, 2, and 3. Who has submitted, they would be filing, you have filed vakalatnama,
No,
would be
Will file.
filing vakalatnama in this case shortly. And also you will be filing written objection against the interlocutory application
yes, lordship.
and also written objection against the interlocutory application filed by the applicant slash appellant. Also, Ms. Kim Payne, learned counsel for the applicant slash appellant, who does not raise any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Obliged, lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 1, Lordship. I'm for the respondent, Lordship. Kindly allow me 1 week time to file my affidavit in opposition, Lordship.
You are Mr. Bedang
No, to Shitamjin.
Toshi. Okay.
Yes, I'm for the respondent, Lordship.
Heard Mr. Toshi Temjin Honginar, learned counsel for the respondent, who prays for a week's time for filing written objection in this review application. Also heard Mr. M. Vero, learned counsel for the revisionist, who does not raise any objection. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Authorized match. May I please, Lordship? Lordship, I beg to mention item number 18, my lord, in the orders column. Lordship, here, as per the office note dated 3/18/26, the service upon respondent number 1 and 2 are still awaited, my lord. So, if this honorable court may kindly allow me to take steps through dusty service, my lord.
You have verified.
My lord, yes.
Heard Mr. M. Vero, learned counsel for the appellant. It appears from the office note dated 3/8/2026 that the service report in respect of notices issued to respondent number
1 and 2.
1 and 2 is awaited. Learned counsel for the appellant prays for allowing the appellant to take steps for issuance of notice upon the aforementioned respondent by way of dusty mode. The prayer is allowed. The appellant shall do so within 15 days. Within a week,
My lord.
returnable on 7th of September. Stop. In the event the appellant is able to serve the notice by dusty mode, it shall, item number
18, my lord.
he shall submit an affidavit in compliance thereto on the next date fixed, list accordingly.
Much obliged, lordship.
For admission, item number 2.
Where is the petitioner?
Petitioner is one S. Gautam.
What is the matter?
Now here the petitioner is challenging a notice which has been issued by the Dimapur East Police Station, summoning the petitioner under the erstwhile or present section 35, which is erstwhile 41A notice under CRPC. Now they are challenging the notice. The FIR or the complaint is yet to be registered.
Now what is to be done?
Your Lordship may proceed with the matter because already for the past 7 or 8 months, petitioner.
Is there any interim?
There is an interim, but it has not been continued.
Okay, then we'll fix it in the next week. Give a chance to the petitioner.
Already several chances has been granted to the petitioner.
No, on last occasion he was present.
Yes, and it was fixed today for hearing.
Okay. None appears for the petitioner on call. Mr. V. Zemomi, learned public prosecutor, as well as Mr. L. Idalu, the learned counsel for respondent number 3, are present. It appears that the scan copy is there.
In fact, Your Lordship, the scan copy may not be required because no complaint has been registered so far. And the notice is enclosed in the petition itself, the section 35 notice.
He has challenged the
Yes, he's
notice.
challenging a notice. And the notice more or less produces the content of the complaint.
How he is agreed with the notice.
In my humble submission, there is no ground so far made out in the petition is premature because the petitioner is basically.
As the petitioner is not represented today, hence this court deems it proper to give one more chance to the petitioner side. Accordingly, list this matter in the next week. You want a fixed date
No,
Next-
after
next-
2 weeks.
after 2 weeks on a date to be fixed by registry.
For admission, item number 6 to 9.
Lordship, uh, Lordship, the counsel for the respondent is on his way. So if the matter can be taken up a bit later.
We'll wait for some time.
Very nice.
Let him come.
Bless Lordship.
Item number 16.
May it please your lordship.
Yes.
Your lordship, here the petitioner is bring for quashing the complaint case, which is pending before the Learned Chief Judicial Magistrate, T3. Lordship, here the innocent petitioner are the accused person.
May I please the lordship? Lordship, in this case, I'm for the state respondent. I'm appearing on behalf of my colleague, Esmeralda Lordship. Lordship, she has some personal difficulty today, Lordship. So if this matter can be listed next week. Your Lordship, I'm for the private respondent. I'm the one who filed the complaint before the Kifri court. So pleadings are complete. In this matter, the state is performative respondent, Your Honor, my lord. So the matter may be heard, please.
It is a complaint case.
Yes, private complaint case.
Complaint case before the magistrate, lordship.
Mr. Zimomi, you can represent this state. Yes.
Lordship, here the innocent petitioner are the accused person who has been implicated as serial number 1 to 7 in the complaint case, 1 of 2026.
No, just a minute.
Lordship, here after the filing of the complaint case,
When the complaint was filed,
Lordship, complaint case was filed on 23rd for 2026, Lordship. Lordship, may kindly come to
by whom?
Annexure 1, page 21, Lordship. That is the complaint case filed by the respondent number 2, Lordship. Annexure 1 at page 21, Lordship.
Okay. Yes.
Lordship, thereafter, by order dated 23/4/2026, that is it, Annexure 2, Lordship, page 122 of my petition, Lordship.
Page 122.
Yes, Lordship, that is it, Annexure 2, Lordship. Yes, Lordship. Thereafter, an order was passed by the magistrate for taking the cognizance notice against the alleged accused person. Now, Lordship, here, the facts before this honorable court is that the petitioner had filed this instant petition for quashing the complaint, which the facts of the case in brief is that, Lordship, here during the year 1973, the Topashi had issued some temporary site permit for the construction of commercial site at Kifiri, Nagaland. Now, which one of the site permit is in the name of respondent number 2, Lordship? The facts leading to the filing of this complaint petition is that, Lordship, in the year 1973, the Tubashi had issued some commercial site for the construction of temporary commercial building. Now, the respondent number 2 is holder of one of the site permit. Respondent number 1, Lordship. Now, Lordship,
Yes.
yes, Lordship, on being learned about the issue of the site permit, the petitioner great grandfather, the petitioner number 1 great grandfather, who is the owner of the land. The petitioner great grandfather, who is the owner of the land, had made a representation before the concerned authority. Lordship, that is at page 123, Annex 3, Lordship. 123, Lordship. On being learned about the issuance of the temporary site permit, the petitioner number 1 great grandfather had made a representation before the concerned department for shifting of private individual building constructed in their own land, Lordship. Thereafter, Lordship, subsequently in the year 2021, that is at page 124. 124. The petitioner number 1 had made a representation, Lordship. That is at page 124.
Yes.
Now, Lordship, after the representation
What representation?
for revocation of the land bata issued in the name of respondent number 1.
Okay.
Yes. Lordship, after making the representation, the deputy commissioner, that is at page 6, Annex 6, page 128, Lordship. Yes, Lordship. After making the representation, the deputy commissioner had issued a circular for a joint meeting in regard to the site permit 112. Now, Lordship, thereafter, while the matter was on the process of settlement, the deputy commissioner had passed an order, that is at page 126, Annex 4. Annex 4, Lordship. Page 126, Lordship. The deputy commissioner had passed in office order dated 23rd November 2023. Lordship, now in the last para, it has been categorically mentioned that the owner of the land is solely in charge of the plot of land. However, in the event of any claim for ownership of the plot under the site permit so by any individual or group, such claimant is at liberty to file a civil suit in an appropriate civil court for redressal. Now, after the passing of this order, Lordship, after the passing of this order, Lordship, the petitioner number 1 had approached the village council court, since it is in ancestral land, village council court, that is at Kefri, Lordship. Since it is in ancestral land, the petitioner number 1 had approached the Kefri village council court, Lordship.
Yes.
Yes. Well, on the process of pending proceeding in the village council court, the respondent number 1 had approached the civil court, civil judge, senior division, Kefri, Nagaland.
Yes.
Yes, well, on the process of pending proceeding before the village customary court, the respondent number 1 had filed before the civil judge, senior division, by way of declaratory suit 2 of 2024, Lordship.
Taking what relief?
Lordship,
What relief was sought for?
Lordship for title on ownership and for permanent injunction, Lordship,
Over which land?
over the site permit 112, now which is in dispute, Lordship.
Okay.
Yes. Lordship, however, while on the process of pending proceeding, the respondent number one, the respondent number one,
That civil suit, what is
Yes,
the
yes.
number of the civil suit?
2 of 2024, Lordship. 2 of 2024,
Before civil judge Kipre?
before civil judge senior division, before Lordship.
Okay.
Yes. No, Lordship, while on the process of pending proceeding, the respondent number one had withdrawn the instant civil suit, which is pending before the civil judge. That is at page 127.
When withdrawn?
It was withdrawn on 16/4/2026, Lordship. Kindly come to page number 127, Lordship. Annexure 5. Page 127, Annexure 5, Lordship. This is the withdrawal made by the respondent number one, Lordship.
What permit was issued?
Site permit 112, Lordship.
But site permit 112 was issued way back in the year
1973, Lordship.
1973.
Yes, yes. Out of this matter, the present petition was erroneous, Lordship. Now, Lordship, after the withdrawal of the declaratory suit 2 of 2024, the respondent number one had filed a complaint case before the magistrate
Alleging what? What
under
is- what is the-
section
what is
Lordship
the-
for defamation, for criminal
Defamation?
trespass. Lordship may kindly come to para 10 of my petition, Lordship. Lordship, para number 9 and 10. Para number 9 and 10 of my petition, Lordship.
Yes.
Is, Lordship, after the withdrawal of the declaratory suit, the respondent number one had filed a complaint case before the magistrate under section 499, 411, 416, 420, 50, and 504 of the IPC. And also to compensate a sum of rupees 5 crore, Lordship. This is the,
No, what was the allegation?
your Lordship, the allegation was that they have made a trespass against the land, Lordship.
Where is that allegation?
Lordship,
Let us go through the complaint.
is, Lordship may kindly come to page 21, Lordship.
Page,
21, Annexure 1, Lordship.
yes.
Yes, this is the complaint petition filed by the respondent number one, Lordship. At para number 34, Lordship. That is at page 58, Lordship. Para 34, page 58, Lordship.
Yes.
Yes. Lordship, my submission before this honorable court is that Lordship may kindly come to do my grounds, Lordship.
Page number.
9, Lordship.
Yes.
Yes. I've mentioned in my para number 567, Lordship. Lordship, the matter was arose due to the civil dispute, Lordship, due to the land dispute. And then the matter is purely of civil nature. Now, my lord, my contention before this honorable court is that they have made the allegation that a parrot was made in and around the land.
What was made?
A bamboo parrot was made in and around the
Okay.
land, Lordship. However, Lordship, if at all, Lordship, after the incident, after the involvement of the district administration, it has already been settled. And then thereafter, only the final order dated 23/11/2023, affirming that the land belongs to the respondent number 2 was given, Lordship. Now, Lordship,
That order is at page.
Your Lordship, that order is at page 1 to 6, Lordship. One to 6, Lordship. After the incident, after the involvement of the district administration, by order dated 23rd November 2023, an order was given stating that the land belongs to the respondent number 1, Lordship. Now, my lord may kindly come to my page number 129, Lordship.
Yes.
Now, Lordship, this is the statement taken before the Chief Judicial Magistrate, Lordship. Now, my lord may kindly come to line number 7, which was taken an oath before the Magistrate, Lordship. Line number 7.
Yes.
I may be allowed to read, Lordship. Based on the order passed by the Tubashi Court, an eviction notice was issued to me by the accused number 1.
No, where are you reading? Line number 7. Page 129.
Yes, page 129. A statement which was recorded before the Magistrate, Lordship. At page 129, Lordship.
Yes.
Yes.
In line number.
Line number 9, Lordship. Line number 10, Lordship. Line number 10, Lordship.
Yes, line
Yes.
number 10.
Yes, Lordship. I may be allowed to read, Lordship.
Yes.
Based on the order passed by the Tubashi Court, an eviction notice was issued to me by accused number 1 on dated so-and-so. After issuing the eviction notice, the accused number 1 came and directed the property on dated so-and-so, when we then wrote a complaint to the Deputy Commissioner. And based on that, the Deputy Commissioner issued an order reconfirming the issuance of the site permit in favor of my father. Now, my lord, as per the statement, the matter has been resolved, and thereafter only the final order was given, Lordship, reaffirming that the land belongs to the respondent number 1. Now, Lordship may kindly come to page number 130. One thirty to 132, Lordship. All these are statements made before the magistrate by the witnesses. My lord, page 130 to 132, Lordship. All these are statements made before the magistrate by the witnesses in the complaint case. Now, my lordship, here my contention before this court is that even if we go through the statement made by the witnesses in the instant case, no specific allegation has been made against any of the alleged accused person, my lord. The assembly stated that people from the Kifri village, however, no specific allegation were made against the alleged accused person, my lord.
And the complainant, whether complainant made,
The complainant as well as the witnesses in the complaint case, none of
complainant
them
also did not make any specific allegation against you.
against any of the accused person who is the petitioner in the instant case, my lord. If we go through the statement made by the witnesses, lordship, none of the witnesses had made a specific allegation to book under this section or against the accused person, my lord.
Yes.
Yes, my lord, thereafter, while the criminal petition is pending before the learned magistrate court, the respondent number 1 had also filed a declaratory suit for titleship in ownership before
Again,
yes, lordship, before the civil judge senior division, lordship, which was admitted on,
what is the number?
yes, lordship. Yes, lordship. With regard to the same plot of land with the same site permit, the respondent, the petitioner number 1 had made a declaratory suit before the learned civil judge senior division in regard to the same site permit, lordship, for permanent titleship and ownership, which has been admitted on 17/7/2026. Lordship, here in submission to my, in regard to my submission, I would also like to place some decision before this honorable court, lordship.
But there are allegations that you threaten the complainant.
No, lordship, as per the statement made before the learned chief judicial magistrate,
Yes.
no specific allegation against the particular accused, lordship. And then the matter was arose due to the land dispute.
How many accused persons are there?
Lordship, there are 1 to 10 accused person. I'm representing for
So
1
the
to 7.
complainant has stated that accused persons have threatened him.
Lordship, however, in the complaint, in the statement made before the magistrate, no specific person has been mentioned, lordship. It is categorically mentioned that people from Kefri town, lordship. Lordship, may kindly come to page 130.
No, but in page number 129.
Yes, lordship, here after issuing the eviction notice, the accused number 1, lordship, that is on 13/10/2023. However, lordship, only after this incident, the order was passed by the deputy commissioner, lordship. After the intervention and after the settlement, the order was passed by the
Okay, that it is on
Deputy Commissioner.
13/10.
Yes,
So on
lordship.
23/10, there was a meeting
Yes.
and
There was a joint meeting. And then after the joint meeting, after the intervention by the district administration, after the settlement of the the Deputy Commissioner had issued the order dated 2023,
So
Lordship.
what is your submission?
Lordship,
What is your submission? Why complaint case is not maintainable?
Your Lordship, my crown is that the matter was arose out of civil dispute, Lordship. And then accordingly, the petitioner number 1 has filed a declaratory suit before the civil judge senior division.
He has again filed a declaratory.
Yes, Lordship.
Okay.
Now, Lordship, with regard to my submission, I would like to place some decision before this honorable court, Lordship. Is Nagaland Law Journal 2023, Lordship, volume 3, Lordship.
23.
Your Lordship may kindly come to page 111. 111, Lordship.
Yes.
Yes, Lordship.
Para?
Lordship, Lordship may kindly come to page 11, para number 6, Lordship. Line number 6, Lordship.
Which para?
Page 111,
Okay.
line number 6, Lordship.
Yes.
Yes. Lordship, I may be allowed to read, Lordship.
Yes.
He has also failed to narrate in the complaint petition as to what exact role was played by the present petitioner in commission of the offense mentioned in the complaint petition. In the absence of any statement in the complaint petition to show as to which accused has committed what offenses and what is the exact role played by the present petitioner. The Honorable Chief Judicial Magistrate appears to have acted mechanically and appears to have taken cognizance of all the offenses quoted by the respondent number 2. Yes. Yes, Lordship. Is Lordship one more decision, Lordship. 2013-11 ECC. 2013-11 ECC. 673, Lordship.
Keep it here.
Page 673. Lordship may kindly
6, 7?
3.
Yes. Which
Yes.
para?
Lordship may kindly come to para 12 and 13, Lordship. Para 12 and 13, Lordship.
Yes.
Yes. I may be allowed to read, Lordship.
Yes.
Yes. Para 12. While exercising its jurisdiction under Section 42 of the Code, the High Court has to be conscious. This power has to be used not only for the purpose of preventing abuse of the process of any court or otherwise to secure end of justice. Whether a complaint discloses a criminal offense or not depends upon the nature of the facts alleged therein. Whether essential ingredients of criminal offense are present or not has to be judged by the High Court. A complaint disclosing civil transaction may also have a criminal texture, but the High Court must see whether a dispute which is essentially of a civil nature is given a cloak of criminal offense. In such a situation, if a civil remedy is available is in fact adopted as had happened in this case, the High Court should not hesitate to quash the criminal proceeding to prevent abuse of process of the court, Lordship. Lordship, now it's certain, Lordship. As we have already noted, here the dispute is essentially about the profit of hotel business and ownership. The pending civil suit will take care of all those issues. The allegation that forged and fabricated documents are used by the appellant can also be dealt with it in the said suit. Respondent number 2 attempt to file similar complaint against the appellant. Having failed, he filed the present complaint. The appellant has been acquitted in another IPC. Possession of the shop in question has been handed over by the appellant to respondent number 2. In such situation, in our opinion, continuation of criminal proceeding would be abuse of the process of law. Now, Lordship, I may be allowed to place one last decision. Lordship, that is 2004 ACC, Lordship. Yes, Lordship. 2004 13 ACC. 421, Lordship. Relevant para, I said 4, 7, and 8, Lordship. 4, 7, and 8. Relevant para, I said 4, 7, and 8, Lordship.
Yes.
Yes. Lordship, para number 7. We have simply noted the contention raised by the parties. The civil court, in our opinion, would be the most appropriate forum to take care of such grievances and pass such interim order as would reasonably protect the interests of both the parties. The civil court may issue an interim injunction, may appoint a commissioner or receiver, or may make any other arrangement as to the possession or user of the property, which is the subject matter of the proceeding in the civil court, exercising the power conferred on it by Section so of the CBC. In view of what has been stated here and above, the appeal is allowed. The proceeding under Section 145 CRPC are directed to be quashed. The parties may approach the civil court, Lordship. We may make it clear that looking to the relationship of the parties, the civil court shall feel free to make such orders as it deems fit consistently with the facts and circumstances of the case, without feeling embarrassed by the limited scope of the suit, which is a suit for permanent injunction, Lordship. Yes, Lordship, so on the above facts, that is my humble submission, Lordship.
Yes. Yes.
May it please your lordship, I'm appearing for the private respondent, respondent number 1. My lord, the facts in the case law represented by my learned friend is contrary to the facts in this matter. So may I respectfully start by making submission that the petitioners, they cannot dictate or challenge the course of action taken by the private respondent against their illegal actions and claim. This petition, my lord, has been filed under Section 528. Now, the petitioners has to satisfy this honorable court that the 3 cardinal requirement of this section, which is first is to give effect to any order under this sanita. Second is to prevent the abuse of the process of court. And thirdly, my lord, to secure the ends of justice. This first requirement is not applicable. Now, the second 2 requirement, which is to prevent the abuse of the court and to secure the ends of justice, the petitioners has to satisfy this honorable court. Now, in order to do that, the embedded scope of this provision is confined and limited to the complaint petition which was filed before the Kifri court. Beyond that, nothing can be considered, my lord. Now, through the complaint, the petitioner has to satisfy this court that no prima facie offense as alleged. There is no prima facie allegation as alleged, my lord. Petitioners has annexed the complaint as annexure 1. So I've already filed my written objection, but I'll be relying on the documents of the petitioners. So to be of some assistance, my lord, I have prepared a chart in which page number and everything has been annexed. Before going into the petition, my lord, a quick brief. The private respondent is a much respected personality in the district of Kifri. The complaint is filed in the district of Kifri. The property against which the dispute has surfaced is in the district of Kifri, my lord. Now, amongst other distinctions, the private respondent, he is also a former member of the Nagaland Legislative Assembly, my lord. Now, I purchased a property which is under site permit 112 in the year 1995 from accused number 8 in the complaint. The present petitioners are accused number 1 to 7 in the complaint, my lord. Accused number 8, 9, and 10, they are not here. They are not present before this court. The complaint has been filed only by accused number 1 to 7. Now, I purchased a property in the year 1995 for an amount of rupees 6 lakhs from accused number 8. Against that transaction, I applied for mutation in the year 2007. Notice was issued as per the standard procedure of mutation. Notice was issued, my lord. And accordingly, my name was transferred, recorded as the legal and lawful owner of site permit 112. Since the purchase in the year 1995, I have been in possession occupation. There's a commercial building in the property, my lord. Since my purchase, tenants are residing. I'm receiving the rental amount as well as I'm paying all the revenue charges till that year, my lord, till that. It's on record, official record of the district administration of Kifri as well. Now, despite that, in the year 2021, the petitioners comes with an application claiming to be the landowners. And on that basis, my tenants are harassed, my reputation is being challenged, is being tarnished, saying that I'm in wrongful possession. I'm not the owner. My property was barricaded, forcefully barricaded, but bamboo walls by the goons of the petitioners and the petitioners, my lord. The district administration, on 2 occasions, I'll bring this on record to those relevant documents, but just in brief, on 2 occasions has affirmed my ownership. Despite that, the petitioners, even as submitted by my learned friend, is admitting that the district administration themselves has admitted that I'm the owner. Despite that, my image is being challenged, tarnished.
No, on 23/11/2023.
Yes, I'll come to that, my lord. I'm not denying that I filed declaratory suit in the year 2024, but it was withdrawn. The reason
No,
was,
before that,
yes,
on 23/11/2023,
yes.
what was held by the DC Kipre?
Again, same, my lord, that I am the owner.
You are the owner.
Yes, again. So my lord, may I take this honorable court to page,
120.
yes, page 74. Page 74 of the petition. Why this document is important? Because this document is annexed as annexure 8 in the complaint. But since it's part of the criminal petition of the petitioner, page 74.
Just a minute.
My lord, this is the actual map. The map in the petition is small. So the larger map, the actual map. My lord, may kindly see that this map has been conducted, this survey has been conducted under the banner of Nagaland Administrative Headquarters Surveys. And then at the top, my lord, can see commenced on 13 March 1979, finished on May 1979. Now I've marked it with red pen. The property, my lord, 112, it's at the center.
No, you are in possession.
Yes, my lord, I'll come to that,
No,
but
his main plea is that there may be dispute between the parties, but it is predominantly of civil nature.
I'll come to
And
that,
you-
my lord, but to come to that, the genesis is very important, my lord.
Okay.
Please.
Yes, yes.
So this is the map. Now, 1979 surveys was done by the government, and then it clearly shows that 112 is at the center. It's been surrounded by various other properties.
Yes.
So kindly come to page 64, my lord, of the
60
same petition. Yes, 64. Now, this is the cell deed, my lord, which was executed on 12/4/1995 with accused number 8 in the complaint. Page 64, my lord, have my lord found it?
Yes.
Page 64. Now, then the property, the site permit was under the name of accused number 8, which is Mr. Vitoku Sema. My lord, the name is very important if it may be kindly noted. Mr. Vitoku Sema. Accused number 8 in the complaint.
Yes.
Is this documents was this Excel and cell deed agreement was executed, my lord? I purchased from Vitoku Sema. Now thereafter, kindly come to page 71, my lord. Page 71. Now after my purchase, I could not immediately apply for mutation since due to various reasons. But in the year 2007, I applied for mutation, and then this is a notice issued by the Deputy Commissioner. This is part of the complaint, is annexed as annexure 6 in the complaint, my lord. Now this notice was issued, which is the standard practice. Through this notice, my lord, claims and objection was invited. Copy of this was issued, was also published in daily newspapers. It was issued also to chairman of Kifri Town Council, SDO Civil, Mr. Vitoku Sema, accused number 8 in the complaint. So when after the expiry of the stipulated period of this notice, since there was no objection, the property was duly transferred under my name and ownership, my lord. Now kindly come to page 62 again. Now this is the site permit. Page 62. Now this is the site permit, and then it was originally issued on 18/8/1973. My lord, survey was done in 1979, but it was originally issued in 1973. Now, the picture, this is the picture of me, my lord, the private respondent. Now, kindly come to next page, 63, my lord. Now, I have been diligently making all the revenue payment charges. Now, kindly come to page against 86, my lord, 86.
Yes.
Yes, this was also issued by the DC of Kifri,
What is this?
confirming that, may I read, my lord?
What is this?
This is notice confirming my ownership over site permit 112. 2021 also issued. It reads as, it is hereby informed to all concerned that the land pata permit number 112 was issued to Sri R.L. Akamba, which is myself, my lord. White office such and such, dated such and such by the then SDO, and the permit is valid and mutated officially as per the mutated pata. Sri R.L. Akamba is the official owner of the land.
Please.
Now this is confirming 2021 DC. Now kindly come to page 87. Now this is the application of the petitioners. Not every petitioners, but by petitioner 1, 5, 6, and 7. This application was filed by petitioner number 1, 5, 6, and 7, my lord. Now through this petition, through this application before the DC,
What was the basis, what they are claiming?
they are the landowners. It was never issued. 1973, it was originally issued. Survey was done by the administration. Pata has been in existence since 1973.
No, what is their claim?
They are the landowners.
On what basis?
The property falls within their territory. Their grandfathers donated the land. Now they are also not disputing that the land was donated, my lord. Now, your honor, your lordship may also kindly appreciate that.
The site permit is in your name.
Yes, is under my name, my lord. Now it's at the center, 112, and it's surrounded by several other site permits. Now, how comes if they are the landowners, why only 112? What about the adjacent properties? How is that even possible? Why only me? Why only against my property, my lord? Why only 112?
Okay.
So through this application, the petitioners are seeking cancellation of my site permit, which has been in my occupation, in my possession since 1995, my lord. Now, kindly come to page 90. Page 90, my lord. 90.
Yes. Okay, their claim is that this property was not donated to the government.
Yes, which is impossible, my lord, given the nature, the present status of the properties. It's been surrounded by several other, it's at the center of the Kifri town.
Okay, yes, page 90.
Yes, page 90, please, my lord. Now, this is a verification report submitted by the head Dobashi of Kifri. Page 90. Now, a verification was sought by the EAC as to whether the property under site permit 112 falls within the donated land or free land, my lord. Now, this letter, this 90 is addressed to the head Dobashi by the EAC. Now, the date is very important, my lord. Date. Date is
2nd November. 28th.
Yes, my lord. It's yeah, 22, 11, 2021. Your Honor, letter was sent to the head Dubashi by EAC on 22, 11, 2021, seeking as to whether the property under site 112 falls within the donated land or free land. Kindly come to next page, my lord. Now the typed copy is on the next, which is 92. 92.
Yes.
Now this is the reply given by the head Dobashi to the EAC. The date again, my lord, which is very important. That is 23/11/2021. Verification was sought on 22/11/2021 within a period of 24 hours. Not even 24 hours, my lord. 23/11/2021. Verification report was given. And then The verification report is very vague, without any substance. no justification.
It created the dispute,
Yeah,
this verification report.
this is also in some sense,
Is the basis.
yes, doesn't change the status, the position, but
But it says for the first time. that
yes,
it is-
now it says it is out of donated land, which is free land, out of donated land.
And therefore the petitioner,
Now, on
Yes.
this, on the strength of this document, this verification report, the petitioner are again extending their claim against me and my property, my lord. Now, kindly, this verification report is also very important, my lord. The content, it only reads as with reference to order such and such dated 22/11/2021. In this regard, 22 follows HGB, name of the Dobashis are given, and then at the last para, as cited above, permit number 112, location near Police Point Kifri is out of donated land. This is for your kind information, please. Just this. Now, it's not relevant in this matter, but whether EAC has the authority to seek such verification, and whether head Dobashi is competent authority. Dobashi's Act is very clear, functions under the administrative authority at the goodwill of DC, my lord. 1979 survey, it's on record, official record. 2021, the DC himself has issued notice that mutation has taken duly, and then accordingly my name has been changed in the site permit. Despite that, now this verification definitely report was submitted by head Dubashi, but whether this will be of any aid or of any value, my lord,
so there is a civil dispute.
I'll come to that, my lord. Now, after that, on this trend, kindly come to page 93. Page 93. Now, the petitioner, on the strength of this document, eviction.
Eviction.
Yes, eviction, I was served. My lord may kindly appreciate that I've been in possession of the property since 1995. The tenants there since 1995 is paying me the monthly rental charges. I'm the one who's paying all the revenues. I'm the one who's taking off the properties. The official record, the administration is the custodian of the record of the district. So in that record, in that district record as well as my name is reflected as the legal absolute holder of site permit 112. Now, despite that, on the strength of this verification report, I was issued. Now, I was given 3 months' time to vacate the property. My lord may kindly appreciate that Nagaland is a small place, and on top of that, Kifri district is much smaller. Now, Nagas are community-oriented society. Now, it's very easy for people to talk what's happening. I've sacrificed my entire life in the service and welfare of my people. I've duly procured the property in 1995 by paying due amount to Mr. Vitoku, accused number 8 in the complaint. As per the standard procedure established by law, I've mutated my name, property under my name. And I'm the one who's paying all the revenue charges. Despite that, eviction notice. On what ground, my lord? Does that not affect my reputation? Does that not tarnish my dignity, my identity, my lord? Which I have established through hard work and sacrifices. 40, 50 years of my...
No, by issuing.
Yes,
eviction
I'll also
notice,
come to that, my lord.
whether it amounts to defamation.
Now, may I read the eviction order, my lord? It is never a pleasure to write this type of letter, but
No,
it has come to our...
The gist of crux of his submission, petitioner's submission is that though there is a civil dispute, undisputed, but you have made out a criminal case to pressurize.
My lord, can you come to page 97? I'll come directly. I was thinking that I'll go categorically, but 97, please, my lord. 97. 97.
Yes, bamboo
Yes.
barricading.
Now, this is the property under side 112. Now, this was done while my name is recorded as the permit holder of site number 112, while it was under my possession, while the tenants were, since 1995, I've been receiving monthly rental charges from my tenant. My tenants were threatened. They were forced to shut down their close. The petitioners and their goons, they came and then barricaded their property.
What offense you are alleging?
Offense is, my lord, for tarnishing my image, for criminal trespass, my lord. Also,
What is the difference between criminal trespass and civil trespass?
civil trespass should be, my lord, to my limited understanding, limited to civil interactions or civil, any actions which can be sorted civilly, but not this, my lord. Can anyone come to anyone's property and on the claim of ownership, barricade the property, my lord?
Then you have civil remedy before civil court.
Yes, but law is also clear, my lord. In same facts, both civil and criminal can also lie. I'll submit those judgments in the later stage, but in the later part, but my grievances is, my lord.
What offense you have alleged?
Alleged is, my lord, for defaming my, tarnishing my image. For criminal trespass, my lord, the picture clearly shows that. Also by cheating by personation, my lord, the petitioners are allegedly, not allegedly, are claiming to be the landowners, and then on that ground, they are taking such criminal actions against me.
No, what offense you have alleged under what provision of law?
Under section 499 IPC, my lord.
499 defamation.
Yes.
And
And 441,
where is that citation? Where have you mentioned that?
in my petition, my lord,
In your complaint?
in my complaint. Kindly come to page 31. Page 31, at the cost title. The complaint under section 223 of BNSS read with section 499, 411, 416, 420, 503, and 404 of IPC.
Okay, show me from the complaint that these offenses are made out.
My lord, the documents I've just shown are part and parcel of the complaint, my lord.
No,
And then-
that shows that you have ownership over the property.
Yes, and then the actions, my lord. This is the action, the reaction. The reaction, page number 97. Barricading my property forcefully. Can that be civil in nature, my lord? Can that be civil in nature? The picture clearly shows, my lord. Is this civil?
Whether every disposition is always criminal in nature.
My lord, my property is under my name, holder. Is my under possession. Despite that, this has been barricaded. My property was barricaded, my lord. I have the Constitution itself, Article 300A.
There was
I have right over property, my lord.
Yes.
I have every right to enjoy my property. Now, if any Tom, Dick, Harry has any grievances against my property, definitely he or she at liberty to initiate appropriate proceedings. But can this validate?
That is my query to you.
Yes, my lord.
That for every trespass, whether every trespass result into a criminal offense,
My lord, if
or
that
is
doesn't,
it a civil dispute where you have remedy before the civil court?
my lord, restraining, forceful restraining cannot be civil in nature. This was restraint. This is restraining, my lord. Forcefully asserting ownership, dominance.
What happens in civil cases.
In civil cases, my lord, since by the way, my lord, the present declaratory suit was filed by the petitioners, not me. So,
Which one, 6 or 2?
yes, recent 2026, my lord. 6 of 20, yes. Now,
They have filed.
yes,
civil
not
suit.
me. And I'll respectfully submit that 2024, I filed declaratory suit, my lord. But
No, the question before this court in this criminal petition is that
Mm,
though the dispute between parties is apparent,
mm,
there is a dispute
yes,
claiming right over
yes,
this, this 112.
yes, property under 112, my lord.
Site permit number 112,
Yes.
both are claiming.
Yes,
But his contention is that though there is a dispute, it is a of civil nature,
yes,
and you have tried to color it.
yes, that's his contention, my lord. But in this,
Till now, you have shown that you have right over property.
yes, and then my right was violated by this also, my lord.
But
Page 97, my
does
lord.
it-
The picture
whether-
clearly shows it has been forcefully barricaded bamboo walls.
whether barricading amounts to,
My lord, now the question is, this application is filed under 528. Now, respectfully, we cannot go into the veracity of the allegation, my lord.
yes, no, what have you?
The prima facie allegation is to show. And if prima facie discloses, then be it complaint or FIR, that cannot be quashed, my lord, especially at the initial stage, at the threshold. Now, whether this will consider criminal or civil remedy, that can be addressed at the later stage, at the appropriate stage, my lord. All that is required at this juncture is for this honorable court to satisfy itself whether prima facie alleged offense is made out.
Yes,
Now, when someone comes to someone's property and forcefully barricades, can that be restrained, restricted? The tenants in the property are forced to shut down the shops. It prima facie discloses the alleged offense, my lord. The property is still under my name, it's still under my occupation. Now, the confirmation, my lord, may I respectfully submit that the confirmation of ownership by the district administration does not in itself absolve the criminal actions of the petitioners. It only proves that the confirmation on 2021 and 2023 by the DC, it only proves that the actions of the petitioners are illegal.
okay.
Now, my lord, to supplement my argument, my lord, may I respectfully be allowed to submit some citations? Wait, okay. My lord, also for the convenience of this honorable court, I've extracted the relevant paragraphs. I've enclosed the photocopies of the judgment also.
Now, how 416 is,
My lord,
before we go into judgments,
okay.
some
Yes.
queries.
Please, my lord, yes.
You have alleged criminal trespass.
My lord,
You have alleged criminal trespass,
yes, and my lord,
441.
yes, my lord.
How 416?
My lord, yes. Very important queries, my lord. Thank you. Now, personation. Why personation, my lord? There is also an issue. Accused number 8 is not in the picture. The present criminal petition has been filed only by accused number 1 to 7. Now, one document is being used by the petitioners against me to confirm his authority over the property. So kindly come to, I'll have to take this honorable court to again page 101 of the petition, criminal petition. (101), my lord. I'll be quick, brief. Now, 101, my lord, this is an affidavit / declaration alleged to have been executed by Mr. Vito Kusema, accused number 8 in the complaint, my lord. Now, I purchased this said property from him only. Now, the operative paragraphs are 4 and 5. May I read, my lord?
In 110.
101, my lord. 101, 101.
Yes.
Now, this is affidavit / declaration, which has been also notarized, my lord. Now, the bare reading of the affidavit will show that it has been alleged to have been executed by Mr. Vito Kusema, accused number 8.
Yes.
Now, relevant paragraph is paragraph 4 and 5. May I read, my lord?
Yes.
That in regard to the said permit located at Police Point, Kifri Town, site permit 112 in question is that I have never sold the land to anyone, nor have I transferred the said land to anyone. However, I have sold only the standing building to Sri Alia Kamba, which is myself, my lord, which was constructed by Sri Toshi Sanktam, his former owner, which I have purchased only the standing building from Sri Toshi Sanktam, as the land solely belongs to Chosemong Sanktam. Now, Chosemong is petitioner number 1, accused number 1 in the complaint, and petitioner number 1 in the instant criminal petition, my lord. 5, my lord. That white order number such and such dated 16/2007, the office of DC Kifri has issued notice for claims and objections with regard to the said permit. However, I have not received, nor notice was made known to me, and I have never received any personal copy. Now, this declaration was not produced by the accused number 8, Mr. Vituku himself, but the petitioners. Now, my lord, after the institution of the complaint case in the trial court, I received this application from Mr. accused number 8 Vitoku on 5/6/2026, which was addressed to the Chief Judicial Magistrate, my lord. And these copies has been served. I've confirmed it has been served to the Deputy Commissioner, Additional Deputy Commissioner, Subdivision, SDO, EAC, Land Revenue, Land Records and Survey Officer, Head Dobashi, myself, and the accused number 1. Now, the second stanza, the second paragraph, my lord, which is just to show that I, the undersigned, have sold a plot of land along with 2-story building to Mr. Alia Kamba Sanktam, which is myself, my lord. And during the period, all necessary documents were duly transferred to him. Now he's stating that. Now the last, my lord, at the corner, last paragraph. Further, I have come to understand that affidavit declaration, which I've just read, my lord, 101. Dated 27 November 2024 was prepared and executed illegally by accused number 1, the petitioner number 1, my lord, on the basis of, to whom it may concern, incorporating additional statements of their own without my consent and without my signature or thumb. That means, my lord, the signature thumb provision of Mr. Vituku was forged, manufactured by the petitioner to support his claim against my property. I categorically state that I have never issued any affidavit declaration on my behalf, and neither had I authorized any person to issue such affidavit. Now, such practice is absolutely illegal, my lord, regardless of whether this document.
But that does not make out a case under 416. It may be a case under 468 or
My lord,
471.
even in respect of allegation, provisions, that can be duly, the competence is with the trial court, my lord. That can be duly addressed. That is not catastrophic, my lord.
Have you alleged that the said document has been forged, that in the certificate.
My lord, it's not me, but accused number 8 himself is that
No,
this is
in
his
your
statement I
in
received.
your complaint petition. In your complaint petition.
My complaint, after the institution of my complaint, this came into surface, my lord.
No, we can go into only the complaint petition.
Yes, but since my lord was asking, continuously asking whether this barricade will civil nature, I'm just trying to, it doesn't need to be considered, but the picture at large, my lord, which is very important. Now, the issue may have both civil and criminal liabilities, which is already settled, my lord. Now, just because civil remedies is available, can I be restrained? Can I be restrained from duly
No,
initiating?
one query,
By recourse.
simple query.
Yes, my lord.
In your complaint petition, where is the accusation made against the present petitioners that they have committed offense under such and such?
My lord, but we filed complaint against 10 accused.
Yes,
10 accused are here before this honorable court. Now,
understand
in respect of these documents,
what is your name?
my lord,
What is your name?
Kitoga Sumi, my lord.
So,
Yes.
Kitoka,
Yes, Sumi.
you listen to my query first.
Yes, my lord.
Show me in the complaint petition filed by you.
Okay.
Listen.
Yes, my lord.
What will you show?
The allegation, my lord.
The
Please, you-
accusations
Yes.
made against the present petitioner,
Mm.
which makes out a criminal case. You show those accusations,
Okay, my lord.
those statements.
Page 58.
You can refer to paragraphs.
Yes, my lord. I'll refer to one paragraph. Paragraph 34 at page 58, my lord. Kindly come to page 58 of the petition. Paragraph 34. May I read, my lord?
No, what is required is from the statement made in the complaint,
Yes, my
you should be able to make out an offense. Only satisfy me that you have been able to make out an offense, alleged offense against the petitioners.
My lord, this is commission of offense. Now, to support this, I have annexed the documents also.
No, listen to me. The fact that there is a dispute, I'm agreeing to that.
Yes, my lord.
The other side has also agreed.
Mm.
But, and there is a civil suit presently pending, that is also admitted.
After the institution of this.
Earlier
complaint.
also it was pending.
Yes.
It was filed by you.
Yes, it was withdrawn, my lord.
Withdrawn. Later on, they have filed a civil suit
Yes,
in
yes.
respect of the
Yes,
said property, which itself shows that a dispute is there.
yes.
The mere fact that a civil dispute is there will not necessarily exclude criminal liability in all cases. If you are able to satisfy this court that a offense is also made out. What I am asking you is, show me from your complaint that I have alleged that this offense in para 34.
My lord, may I kindly take this honorable court to page 54?
54.
I'll have to read certain paragraphs. It starts with, may I start with para 23, my lord?
Yes.
That at the cost of repetition, it is reiterated that the complainant is the absolute and legitimate owner of the property under site permit 112. The complainant legally purchased the property from accused number 8 after making payment of rupees 6 lakhs. The said transaction between the complainant and accused number 8 was effectuated by executing sale deed dated 12/4/1995. Further, after the purchase of the property, as required under law, the complainant applied for the change of ownership before the DC. Accordingly, after issuing notice that such and such property under such permits was muted in my name. 24, my lord. It is respectfully submitted that
These
since...
you have already submitted this.
Yes, my lord. Now the facts in itself is proof of evidence, my lord, of the allegation which has been alleged. Now, there is no, without facts, my lord, there is no allegation. From the facts itself, we have to extract the allegation, my lord.
No, your para 27, come to your para 27.
Yes.
What you want to say?
Now when, my lord, there it says that it is respectfully submitted that the complaint is being represented as an impostor, fraudster, forger, deceiver, oppressor, usurper by the accused. Now, there is no written, but when someone said I'm in wrongful operation, this is actually implied, my lord.
No. Merely saying that you are in wrongful possession does not amount to an offense under 4.
That means I have come into possession of this property by illegal means, my lord. That's what the accusers, the petitioners are
Your
saying.
submission is that saying that amounts to defamation.
Yes,
And-
because my
and
image is
in-
tarnished, my lord.
In impersonation.
Yes.
Okay.
Now, my respectful submission is, my lord, in order to ascertain as to whether prima facie allegation is made out or not, the facts needs to be considered. Because without the facts, no case can be considered whatsoever, my lord. There cannot be any separate facts to satisfy the allegation. It's just that the facts which is before this honorable court has to be addressed, has to be considered, my lord.
And your submission is that the facts alleged
Yes.
constitute offense.
Now, my lord, now insofar as the claim of the petitioners against my property is concerned, it may be of civil nature, my lord, but their reaction on the basis of such claim against me and my property is not civil, my lord. Their claim might be, the nature of their claim might be civil nature, but the consequences suffered by me and my property is not civil, my lord.
Okay.
Now, to conclude my submission, my lord, may I be allowed to... I've already given, right? Yes. The first citation, my lord. Also, before going to this, my lord, I must take this honorable court through the grounds of the petitioners, which is at page 9, my lord. Paragraph 11.
Yes.
Yes, my lord. Page 9, paragraph 11. So first ground and second ground is, for that the impugned order passed by the learned Chief Judicial Magistrate is bad in law and liable to be interfered with and quashed. This order is precognizance order, my lord. Now the second ground, for that even if the complaint filed by the respondent number 1 is taken to be true as its face value, there exists no grounds for the learned magistrate to come to the conclusion for the existence of any offense of cognizable nature committed by the petitioner. Now to this ground, my lord, I'll have to read section 26 Section 223, proviso of the BNSS, my lord. Section 223, proviso, BNSS.
Yes.
My lord, it reads as that provided no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard. All the learned trial court is doing is following the
Till
provision, my
now,
lord.
cognizance has not yet been taken.
Yes, precognizance notice, my lord.
Okay.
The provision clearly says so. So ground number 1 and 2 is not maintainable, my lord. Ground number 3, my lord. For that, the facts as disclosed in the complaint filed by the respondent number 1, complaint is of civil nature, which the matter has been arose due to dispute in the site permit covered by permit 112.
Is there any stay of the proceedings
No, my lord, there is no stay.
before the trial court?
Yes, yes.
When is the next date fixed?
Next date is 13th of this month, my lord.
For?
For precognizance is still at that stage.
Okay.
They haven't entered appearance, my lord. They definitely have entered appearance to counsel, but the proviso says that after hearing the accused, so that has not taken place, my lord. Now, my lord, insofar as ground number 2, 3 is concerned, my lord, may I respectfully submit that just because the property, the issue is in respect of immovable property, that does not confine, limited to civil in nature, my lord. The claim of the petitioners against me and my property, definitely it may be in civil in nature, but his action committed against me and my property, 101, page 101, barricading, my lord, threatening my tenants, forcefully shutting down my tenants' business, my lord, affecting my rights over the property, definitely is not civil in nature, my lord. So my respectful submission is this ground is also not maintainable. Now, number 4, my lord. For that, while the respondent number 1 had instituted a declaratory suit bearing declaratory suit to 2024 for declaration and permanent injunction, declaring title and possession over the sued land, and while during the course of pending proceeding, the respondent number 1 by dated such and such had withdrawn the matter and subsequently instituted complaint case before the Chief Judicial Magistrate with the intent to just harass and blackmail the petitioner. Now, my lord, we kindly appreciate that the property is still under my name. I'm still paying the revenue. I'm still receiving the rental amount from my tenants. Therefore, I have no cause of action against the petitioner accused despite their claim against my property. So I withdrew. Now, just because I withdrew my civil suit, my declaratory suit, can the petitioner allege that the instant complaint has been filed to harass, blackmail? What? I don't need anything from the petitioner, my lord. They are the one who is after my property. They are the one who's tarnishing my image, my lord. This is not harassment. This is not blackmailing, my lord. This is my asserting of criminal law, my lord. So ground number 4 is also not maintainable. Ground number 5 is for that the allegation made by the witness in the complaint case before the learned Chief Judicial Magistrate did not disclose any specific allegation made against any particular accused petitioners for the commission of offense. Now, who committed what, my lord? That will be decided only at the trial. Conveniences. And for this also, I must take this over court to page 130. 130, my lord, of the petition, criminal petition, page 130.
Yes.
Now, this is a statement by the witness number 2. 130, my lord. May I read, my lord?
Yes.
My father opened his shop since 1972, after which I took over. In the end, 2021, people came from Kifri town to the shop about 6-7 times and told me that they were the owners of the land and they would break the shop. They asked us to leave the shop and they would dismantle the shop. They would threaten us that way and even tell us that they would hurt us. When my dad was alive, we would give rent first to Toshi, then Vitoku. Vitoku is accused number 9, and then Arelakamba, which is myself, my lord. Now they've been threatened, they've been So, my lord, this ground is also not maintainable. Now, number 6, my lord, ground number 6 is for that the statement made by witness number 1 in complaint case before the learned Chief Judicial Magistrate Nagaland amply proved that the matter have been resolved on the intervention of district administration before the final order that is such and such 2023 issued by DCK Free that the said permit belongs to respondent number 1. Subsequently, after withdrawal of pending of the declaratory suit before the civil judge for permanent injunction and title over the site permit, the respondent number 1 has filed the instant complaint case with an intent to harass the petitioners. My lord, there is no settlement. Notice issued by, the office order issued by the DC was confirming my ownership over the property. Now, when the DC, again, despite the actions, the repeated against actions of the petitioners, when the DC confirms my ownership over the property, it simply proves that their actions are illegal, my lord. The petitioners' actions are illegal. And when it's illegal, it's criminal in nature, my lord. So, ground number 6 is also not maintainable. Ground number 7, my lord. For that, the order passed by the learned trial magistrate is based on irrelevant consideration, non-application of mine in proper perspective. This is also, my lord, not maintainable. Number 8. Now it is well settled principle of law and criminal jurisprudence that the law and judicial process should not be used as an instrument of oppression or needless harassment. The facts narrated in the forging paragraphs clearly demonstrate that the impugned complaint case is filed only with the intention of harassing the petitioners under complaint number such and such. BNSS needs to be questioned for. There is no harassment, my lord. There is civil law and criminal law. All I'm doing is I'm invoking my criminal rights, my protection, my lord. So this ground is also not maintainable. And lastly, 9, my lord, for that delegation complaint, even if taken on their face value, do not consider any offense under section such and such. And as such, to secure the ends of justice, the instant complaint needs to be questioned, my lord. From the facts of the matter at hand, my lord, it is amply clear, my lord, the property is still under my name. I'm duly receiving rental charges. I'm still paying the revenue. Now, despite all those, and then my ownership is also duly reflected in the official records of the administration, survey of 1979, which clearly records that 112 is at the center, surrounded by several others. Despite with this bogus claim, when someone comes to my property, forcefully barricades by bamboo wall with bamboo wall, my lord, tells threatens my tenants that they are the owners, my lord. I'm not the owner, my lord. Criminal allegation, my lord, is made out.
Okay. Now come to your judgments.
Judgments, okay, please, my lord. Authority number 1, my lord. Did you share? I have extracted the citation, so for your convenience. I've also enclosed the photocopy of the case laws, but
This not.
for easy reference, my lord, this is convenient, paragraphs and all. Authority number 1, in K. Jagdish, my lord. First page, my lord, first page. Authority number 1, 2020, 14 SSC.
Just looking at how much cases you have.
Just 3, my lord, just 3.
Okay. Yes.
Paragraph 8, it is well settled that in certain cases, the very same set of facts may give rise to remedies in civil as well as in criminal proceedings. And even if a civil remedy is availed by a party, this is important, my lord. Even if a civil remedy is availed by a party, he is not precluded from setting in motion proceedings in criminal law.
Yes.
Number 9, there are a large number of cases, para 9, cases where criminal law and civil law can run side by side. Two remedies are not mutually exclusive, but clearly coextensive and existentially differ in their content and consequence. It is anathema to suppose that when a civil remedy is available, a criminal prosecution is completely barred, my lord. Two types of actions are quite different in content, scope, and import. Para 11, criminal prosecution cannot be thwarted at the initial stage merely because civil proceedings are also pending. Para 12, criminal cases have to be proceeded with in accordance with the procedure as prescribed under the CRPC and dependency of a civil action in a different court, even though higher in status and authority, cannot be made a basis for questioning of the proceedings. Para 13, High Court ordinarily would not exercise its inherent jurisdiction to quash a criminal proceedings and, in particular, a first information unless, in this case, complaint, my lord, unless the allegation contained therein, even if given face value and taken to be correct in their entirety, disclose no cognizable offense. 2, for the said purpose of the court, save and except in very exceptional circumstances, would not look to any document relied upon by the defense. 3, such a power should be exercised very sparingly. If the allegations made in the FIR, in this case complaint, disclose commission of an offense, the court shall not go beyond the same and pass an order in favor of the accused to hold absence of any mens rea or actus reus. 4, if the allegation discloses a civil dispute, the same itself may not be a ground to hold the criminal proceedings should not be allowed. The law is settled, my lord. In this case, I'm not saying there is no civil dispute, but can that bar criminal proceedings? Absolutely no. Law is settled, my lord. Number 2, authority number 2, para 8, my lord. If the complaint makes out a case for prosecution answering all the requirements of the offense alleged against the accused, then the complaint, this is before the Bombay High Court, my lord, initiated thereunder cannot be quashed and set aside under section 482. Para 9, principles to exercise jurisdiction under 482 to quash complaints and criminal proceedings are: 1, a complaint can be quashed where allegations made in a complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out the case alleged against the accused. For this purpose, the complaint has to be examined as a whole, my lord, as a whole, which means the documents included, my lord. But without examining the merits of the allegation, allegation cannot be examined, my lord. Neither a detailed inquiry nor a meticulous analysis of the material or an assessment of the reliability or genuineness of the allegation in the complaint is warranted while examining prayer for quashing a complaint. Settled, my lord. Number 2, a complaint may also be quashed where it is clear abuse of the process of court, as the criminal proceeding is found to have been initiated with malefides, malice, or wreaking vengeance, or to cause harm, or where the allegations are absurd and inherently improbable. In this case, I'm the victim here, my lord. I'm the one who's been continuously harassed. Number 3, the power to quash shall not, however, be used to stifle or scuttle a legitimate prosecution, my lord. Legitimate prosecution. The power should be used sparingly and with abundant caution. Number 4, the complaint is not required to verbatim reproduce. This is important, my lord. The complaint is not required to verbatim reproduce the legal ingredients of the offense alleged. It is if the necessary factual ingredients have not been stated in detail, the proceedings should not be quashed. Quashing of the complaint is warranted only where the complaint is so bereft of even the basic facts which are absolutely necessary for making out the offense. It's amply clear now, my lord.
Okay.
Number 4, given facts. So, a given set of facts may make out purely a civil wrong or purely a criminal offense, or civil wrong also a criminal offense, my lord. Now, last, authority number 3. Para 25. High Court must exercise its inherent power under Section 482 sparingly and with circumspection. Inherent powers not to confer an arbitrary jurisdiction on the High Court to act according to whim and caprice. Para number 29, my lord. The test to be applied is whether the allegation in the complaint as they stand, without adding or detracting from the complaint, prima facie establish the ingredients of the offense alleged. At this stage, the High Court cannot test the veracity of the allegation. For that matter, can it produce in the manner that a judge conducting a trial, my lord, would, on the basis of evidence collected during the course of trial. My lord, my respectful submission is, the criminal petition of the petitioner is devoid of any merit whatsoever. His claim against me and my property may be civil of nature, but his action definitely committed. His reaction against me and my property is not civil, my lord. Also, my lord, the stage before the trial court is still at the threshold. The requirement, the 2 cardinal requirement, 3, the first requirement is out Now the two requirement, which is to prevent the abuse of process of court and
What is the first requirement?
to ensure the order of this Sanita, my lord, the requirement of section 528, three cardinal requirement, my lord.
Yes, what?
First is, yes, 528, my lord.
Yes,
Three cardinal requirement is, first is to give effect to any order under this Sanita, CRPC now Sanita BNSS. Second is to prevent the
Okay.
abuse of the process of court.
okay,
And
okay,
third,
done.
to secure the ends of justice. Now, the petitioner has miserably failed, my lord. So my respectful submission is this petition is maybe dismissed with exemplary cause. At least 1 lakh, my lord, please. At least 1 lakh. With exemplary cause, at least 1 lakh. He is the one who is coming after my property, my reputation. He is the one who's confining, barricading all my property, and then he is saying that I'm harassing him.
Okay. Heard. Mr. Toshi Tenjin Bongner, the learned counsel for the petitioners. Also heard Mr. Kitoka Sumi, the learned counsel for the respondent number 1. Mr. Zimomi, you have any submission, anything to add? Also heard Mr. V. Zimomi, the learned public prosecutor representing the state respondents. Stop. This application under under section 528 of BNSS 2023 has been filed by the petitioners praying for. You may take your seat. I'll give a part dictation. I'll give.
Okay.
Has been filed by the petitioners praying for quashing the complaint case number 1/2026, which has been filed by the respondent number 1 before the Court of Learned Chief Judicial Magistrate Kipre under section 499/441/416/420/503 and 50/504 of the Indian Penal Code. The petitioners have also impugned the order dated 23/4/2026 passed by the learned Chief Judicial Magistrate Kifere in complaint case number 1/2026, whereby where is this order? Annex as annexure. At which page?
Page 122, annexure 2.
122, just a minute. One to two or
122, annexure 2, page number 122.
222.
Yes, yes. 122,
Okay.
annexure 2.
What was the last line? Whereby notice to the petitioners was issued by the trial court at pre-cognizance stage under section 223 of BNSS 2023. The next para. The facts relevant for consideration of the instant criminal petition, in brief, is that the that in the year 1973, the then town Dobhashis had issued temporary site permit for construction of commercial building bearing site permit number 112 in the name of the present respondent number 1. Namely, Mr. R.L. Akamba Sanctum. Stop. It is alleged in the instant criminal petition that the said site permit was issued to the respondent number 1 without the knowledge of the landowner, that is, the grandfather of the present petitioner number 1. And as such, the district administration was approached by the petitioner's side for revocation of the said site permit. Stop. It is further pleaded in the instant criminal petition that on the basis of representation filed by the present petitioners, the Deputy Commissioner Kipre had passed an office order dated 23/11/2023, whereby it observed that the land covered by site permit number 112 belongs to the respondent number 1. However, an observation was made therein that in the event of any claim of ownership, such claimant is at liberty to file a civil suit in appropriate civil court for redressal. Stop. Next para. It is further pleaded in the petition by the petitioners, in the present petition by the petitioners, that thereafter, owing to the dispute over land covered by site permit number 112, the petitioners approached the Kipre village council court, Kipre, to adjudicate the dispute as per the customary law applicable to the parties. Stop. However, during the pendency of the matter before the customary court Kipre, the respondent number 1 filed a civil suit, filed a declaratory suit before the Court of London Civil Justice Senior Division Kipre against the present petitioners. Stop. The said declaratory suit was registered as declaratory suit number 2/2024. Stop. However, later on, the said declaratory suit was withdrawn by the present respondent number 1. On respondent number 1 on 8/5/2025, full stop. Mr. No, 8/5/2025. Thereafter, the respondent number 1 filed the complaint case What is the number of the complaint case?
5 or
Complaint,
26.
complaint case 5 or 1?
5. It's not 1, my lord. It's wrongly reflected. It's 5 actually.
Complaint case before the Court of London Chief Judicial Magistrate alleging over the same matter, alleging commission of offense by the present petitioners under section 499/441/420/503/504 of the Indian Penal Code. The said complaint case was registered as complaint case number 5/2026, which is sought to be quashed in the instant by filing the instant criminal petition. Mr. Toshi Temjen Pongene, the learned counsel for the petitioners, submits that though there is a dispute between the petitioners and the respondent number 1 in respect of land covered by site permit number 112. However, the dispute is purely of civil nature and the respondent number 1 has, in view to harass the present petitioners and to pressurize and to put pressure on them has tried to give the civil dispute a cloak of criminal offense. He further submits that in the complaint petition filed by the present petitioners before the trial court, no specific allegation has been made against the present petitioners, specifying the act committed by act or omission committed by the present petitioner which constitute any offense which has been alleged in the complaint petition by the petitioners, by the respondent number 1. He further submits that the materials available on record, including the order passed by the Deputy Commissioner Kipre on 23/11/2023, clearly indicates that the dispute between the parties are of civil nature and as such, it would be abuse of the process of court to allow continuation of the complaint case, allow continuation of the criminal proceedings against the present petitioner in form of the complaint case number 5 of 2025 or 6, 2026, pending before the Court of London, Chief Judicial Magistrate Kipre. He submits that the allegations made by the respondent number 1 in his complaint petition regarding putting of bamboo barricading against the disputed land. No, not allegation, the grievance of made by the bamboo barricading against the disputed land may be redressed by a civil code as civil courts have authority to issue ad interim reliefs in form of issuance of injunctions or appointment of commissioner or receiver or any other such interim arrangement as regards the possession or user of the property in dispute. He further submits that the dispute between the parties are predominantly of civil nature, which is also disclosed in the averment made in the complaint petition by the respondent number 1. He submits that in such a situation where civil remedy is available to the respondent number 1, this court should not hesitate to quash the criminal proceeding to prevent the abuse of the process of the court. Stop. In support of his submission, the learned counsel for the petitioner has cited following rulings. Number 1, Branch Manager, Federal Bank, Dimapur, Nagaland versus State of Nagaland, reported in 2023, 3 NLJ 96. Number 2, Paramjit Batra versus State of Uttarakhand and others, reported in 2013, 11 SCC 673. Number 3, Mahar Jahan, MAHR, Jahan and others versus State of Delhi and others, reported in 2004, 13 SCC 421. Stop. On the other hand, Mr. Kitoka Sumi, the learned counsel for the respondent number 1, has submitted that the trial court is yet to take cognizance of offense on the basis of the complaint petition filed by the respondent number 1 before it, and it has only issued notice at pre-cognizance stage under proviso to section 223 of the BNSS. As such, he submits that this is not a fit case to invoke the extraordinary inherent powers of this court under section 528 of the BNSS to scuttle the criminal case at the initial stage. He submits that the present respondent number 1 has purchased the land covered under site permit number 112/112 from the accused number 8 in the complaint case, namely what is his name?
My lord?
Vitoku Sema.
Yes, Vitoku Sema.
Vitoku Sema. In the year 1995, He further submits that after purchasing the land, the petitioner, the respondent number one, also applied for mutating his name in the records of right, and accordingly, his name has also been mutated in the records of right in respect of land covered under site permit number 112. He also submits that the respondent number one has been regularly paying land revenue in respect of the said land, and in the building constructed over the said land, he has tenants who are paying rent to him since 1995. Stop. He further submits that the deputy commissioner Deputy Commissioner Kipre in order dated 23/11/2023 have also acknowledged the fact that the land belongs to the present respondent number one. He also submits that merely because the civil suit, merely because the declaratory suit number 1/21 of 2022. What is the number of this?
2 of 2024, which was withdrawn.
2 of 2024, which was withdrawn by the present respondent number one. The petitioner are not given any license to criminally trespass into the said land and threaten the respondent number one and his tenants. He submits that the facts narrated in the complaint case by the respondent number one makes out offense alleged in the said complaint case. He further submits that it is not necessary for the complainant to verbatim reproduce the legal ingredient of the offense alleged in the complaint. He submits that what is necessary is that the ingredients should be ingredients of alleged offense should be made out from the facts alleged in the complaint petition, which he is able to do. He also submits that though the dispute between the petitioners and the present respondent is also of civil nature, but that in itself does not mean that it precludes a criminal trial if the offense, if it also makes out a case under any penal law against the petitioners. He submits that same set of facts may give rise to different kind of disputes. The dispute may be purely civil in nature or purely criminal in nature, or maybe both civil and criminal in nature. He submits that in the instant case, the acts committed by the petitioners on as alleged in the complaint petition constitute the offense alleged against the petitioners in the complaint petition. As such, this is not a case where the facts disclosed in the complaint petition does not make out a case, does not make out an offense against the petitioner. As such, invoking jurisdiction of this court in washing the complaint petition is uncalled for. Stop. Next para. He further submits that the inherent, he further submits that there are catena of rulings of the apex court wherein the legal proposition regarding legal proposition as to power of this court under section 528 of the BNSS/482 of the Code of Civil Procedure 1973 has been settled. He submits that the power of this court under section 528 of the BNS should be sparingly exercised with circumspection. He submits that as the petitioners have failed to make out a case for invoking the inherent jurisdiction of this court, the instant inherent jurisdiction of this court for interfering with the criminal proceeding of complaint case number 5/2026 pending before the Court of Learned Chief Judicial Magistrate Kipre, the instant criminal petition should be dismissed with exemplary cause. Stop. In support of his submission, the learned counsel for the respondent number 1 has cited following rulings. Number 1, K. Jagdish versus Uday Kumar, GS and another, reported in 2020, 14 SCC 552. Barbail Khimji Shah, Barbeil Khirmji Shah versus State of Maharashtra and others, reported in 2007, 6 MHLJ within bracket Bombay High Court. Next, Jitul Jentilal Kotecha versus State of Gujarat, reported in 2022, 13 SCC 652. Stop. Mr. V.V. Zimomi, learned public prosecutor, has submitted that he adopts the argument. Which side you are? Adopts the argument of the learned counsel for the respondent. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. Stop. Remaining portion I will dictate in chamber. I may declare the result. The criminal petition is dismissed for reasons to be stated in the judgment.
complaint case, like other cases, a chair case was registered. Therefore, the petitioner moved an application before a sitting judge to release the articles in
Session Judge Dimapur.
Yes, Dimapur, to release the goods in Zima because the articles are perishable items.
Yes.
Sitting court passed order to release it,
Okay.
but then it was not released on one or the other occasions. Therefore, after several approaches, it was not released despite of the court order. Therefore, the petitioner was compelled to file a writ petition before this honorable court, challenging the decision and also prayed for release of this article since in spite of the order. passed-
But release order was already there.
Already there, but they have not released. That's why I have no other choice.
Okay.
We approached this honorable court and by order dated 9 October 2025, that is 9 April 2025, this honorable court passed the order in WPC number 42 of 2026.
Yes.
9/4/2026 was the order passed by this honorable court, directing the respondents to release the goods immediately.
Okay.
But the meaning of immediately may not have been understood by the custom officials. They have retained. And thereafter they filed an application saying that you should have completed the Commissioner of Customs, notice in charge. Because under instructions, we have.
No, writ petition was disposed of.
No, it is pending.
Pending. Okay.
So they have completed. Thereafter, after the enlightenment, it is not released. So on 20 July, that is the latest order, 20 July 2026, this honorable court passed an order. Submission was made by the counsel for the respondent that we will comply with the order. Oh, sorry, Lordship. Before that, a contempt was filed. Since they are not releasing in spite of the order passed by this honorable court on 9/4/2026, a contempt petition was filed. And in a contempt petition, notice was issued. All after completing all the formalities. For the last time, the order was passed by this honorable court in the contempt petition on 20 July 2026. And submission was made that we will file affidavit about the complaints to the order. And then this honorable court fixed this matter to be listed after 2 weeks. And they have to inform the honorable court about the complaints. I cannot know what instructions my learned friend has. With regard to the criminal one, they have filed an application before this honorable court challenging the order passed by the district court. Sitting court,
This petition has been filed by the state.
by the customs, criminal petition, because there we
Okay.
have, I'm just.
Let him complete.
There, under section 110A of the Customs Act, there is a provision to approach the authorities. And the learned sitting judge do not have the jurisdiction to pass this order. That was the challenge they have made in the criminal petition. But by this time, this honorable court has already passed order as part by clause on 9 April 2026. And in the contempt also, it was already pending. During the pendency of all this, they have filed the latest this criminal petition, challenging the order passed by the Citizens Court Dimapur. My submission in this background is rightly or wrongly, the Citizen Court has exercised its jurisdiction that was not complied with by the respondents. And he has exercised the power because of the fact that a chair case was registered. So apparently he may have invoked his jurisdiction. But in the meantime, the petitioner has approached this honorable court.
By filing WPC.
Yes, for relates and then challenging the and this honorable court has passed an order on 9/4/2026. And thereafter also they have not acted upon the order. They were playing illegals. And it is a perishable item, knowing fully well that it is, if it is not released on time, it is subject to variation the items. Now, when contempt was pending, they have filed this present. Now.
When contempt was filed,
Contempt was filed on.
when it was filed,
16/4/2026. And it was moved on 17.
and when the present criminal petition has been filed,
It was filed. 8/16.
which date? 8.
8/16. That is the date of motion. And that day it was moved. It was.
Yes.
So, if we are to proceed with a criminal proceeding, it will be an academic exercise. Once the courts are released in due compliance of the order, then half of the relief will be granted. And then to go for a.
Whether the seized area cannot have been released.
It's not released.
By releasing the Arepan, the purpose of the customs tax. So after submission, I will
That is very simple, Lord Chair. We are taking the order of this honorable court for a right.
Your worship,
No one.
If we are not, if it is not passed in accordance with law, what prevented the respondent authorities to challenge that order passed by this honorable?
In writ petition.
Yes,
Yes.
but they have not filed any appeal. Not taken it, just withholding. That objective is very clear, just in order to delay and waste the items. That is the objective. And apparently knowing fully well that this is premise origin.
Now, in writ petition, the relief was granted by way of interim order.
Yes. Yes, you could have challenged that also. That's in part of that.
Yes.
below the interim order, 9/4/2026. The basis of passing that order is to karate.
Interim order in develop.
In WPCB of P2.
Is it annexed along with this petition?
It's club, better.
No, in this criminal petition,
Criminal petition though. The criminal petition, your worship, my criminal petition, an annexure B, your worship, it's the seizure. Seizure memo, and worship, on what basis the goods were seized? First of all, your worship, there is this office memorandum, annexure P, page 40.
page
40 of the criminal petition.
yes.
Yes. Okay. The smuggling of first item, including articles from and other of the states under the cover of timber challan issued, raised in department related parliamentary solutions. Please refer to info dated so on the above subject, where the issue related to smuggling of first items, including articles from Nagaland and from state under the cover of timber challan issued by the forest department has been highlighted. And number 4 question. The issue related to smuggling under the cover of fancy pass issued by Manipur Forest Department has come to the notice of the department. Gauhati Customs and CGST zone, as well as the Director of Revenue and Intelligence, are highlighted constraint in the enforcement operation consequently on the issuance of order by the government of Manipur on 11 January 2023 by so and so. The by the same order dated 11/1/2023 rule 47/5 and 47/6 of the Manipur Forest Rules 2021 have been omitted to enable the Manipur Forest Department to regulate and release the transit permit fee from the forest produce imported into the state without custom clearance. The erstwhile omitted rules so of the Manipur Forest Rule 2021 contains provision for seizure and confiscation of such goods under IFMA 2018 and
What is IMFA?
Indian Indian Foreign and did not allow compounding in the case of illegality of forest produced from other countries including Manipur. The omission of this rule has thus created the possibility of misuse as smuggling may exploit the smugglers may exploit this opportunity to legitimize smuggled goods, even if goods are bought illegally into the state by bypassing customs control. The Manipur government can still issue EPs allowing the smuggled goods to be transported under the cover of these permits. Instances have been noticed where smuggled marijuana intercepted by the security agencies, agencies have been auctioned by the state forest department on the spot, and there are transfer pass issued for transportation of such goods. This seems to be a direct contribution to the provision of the Customs Act 1962 and has created several operational difficulties in enforcing the relevant provision of Customs Act vis-a-vis smuggled goods. So on this basis, when the practitioner has acquired some goods, the seizure was done. If the seizure memo to be also at page number 22, and it should be
Yes.
at point number 16. Details of goods seized. Brownish colored dry American nuts believed to be of foreign origin. Quantity is 45,600 kgs. Of dry American nuts packed in 507 numbers of caliber. Your worship, may go page number 38. Worship. Page number 38 is the permit, your worship. Council permit issued by the state of Nagaland. Here, your worship, in column 6, the kind of work is measurement of cubic content or weight. Here it's 15 metric ton. And in page number 41. The measurement cubic content or weight is 10 metric. So your worship, the transit pass in the possession of the person while these goods were seized was only for 25,000 meters. And the department has seized a total of 45,680. Further, your worship. For the efficiency judge, a person, namely Robinson, has filed a Zima application, which was numbered as Zima application number 50 of 1956, which was later withdrawn on 16/2/2026. Thereafter, Your Lordship, the petitioner approached the Sessions Court by filing IA number 82 of 2026 for release of the seized goods. And the current district judge has released the good to the petitioner. To release the goods to the petitioner. So, Lordship, first of all, the Customs Act is a special act, Lordship. The Sessions District Judge does not have the authority to pass such an order. Under the Customs Act also, Lordship, there is a specific provision under section 110A for provisional release of goods, documents, and things seized pending adjudication. Any goods, documents, or things seized under section 110 may, pending the order of the adjudicating authority, be released to the owner on taking bond from him in proper form with such security and conditions as the adjudicating authority may require. Here, Lordship, the adjudicating authority is the Commissioner Customs, Lordship.
Section one,
And
110(1)(a).
yes, Lordship. For provisional release. For your Lordship, under section 123. 123 of the Act, Lordship. Burden of proof in certain cases. Where any goods to which this section applies are seized under this Act, in the reasonable belief that they are smuggled goods, the burden of proving that they are not smuggled goods shall be, in case where such seizure is made from the possession of any person, on the person from whom possession the goods were seized. And if any person other than the person from whom possession the goods were seized claims to be the owner thereof, also on such other person. So the owners of proving that these are not smuggled goods, the petitioner should approach the adjudicating authority, Lordship. That is the Commissioner Customs, Lordship. In a similar case, Lordship, this honorable.
No, Commissioner Customs is the adjudicating authority. Under what provision?
For
'Whom seizure was reported?
the seizure was done by the senior intelligence officer.
To whom it was reported?
Reported to the customs.
Not,
After they were seized, they have been deposited to the godown.
but a GR case was registered.
GR is here. How the confusion has been made is because of section. One zero four.
What is there?
Power queries. If any, if an officer of customs empowered in this behalf by the bureaus, or special order of the Municipal Commissioner of Customs, or Commissioner of Customs has reason to believe that any person in India or within the Indian Customs border has committed an offence punishable under section 132 and 133 of so he may arrest such person and shall, as soon as there may be, inform him for the ground of such arrest. To your Lordship, every person arrested under this section shall be without unnecessary delay be taken to the magistrate. Lordship. The persons who are arrested are handed over to the state authorities. Lordship.
And Caesar matter is looked after by
With the
where? Show me the provision.
under 1
1
110. Zero. If the local officer has reason to believe that any goods are liable to be confiscated under this act, he may seize such things. Provided that where it's so particular party.
Whether any customs case was registered.
Yes, Your Worship. The case was registered under the customs of the Worship. The customs case, is registered as in my procedure is case file page number 32. This number is 2/CL-IMP Arikana D Arika/DRI/EIRU 2025-2026 dated
Page number?
In page number 32.
Who adjudicate whether it is a smuggled good or not?
The Commissioner Customs.
Where is that provision?
The corporate officer. That's all. The corporate officer is the educating authority. Educating authority. Education of the institution. Section 1 in every case under this chapter, in which anything is liable to compensation or any person is liable to a penalty, such compensation or penalty may be adverse without limit by the Municipal Commissioner of Customs or Commissioner of Customs or a Joint Commissioner of Customs. The process made by such officer as a board may notify his business. So the corporate officer is the Municipal Commissioner of Customs, or in this case, Customs of Commissioner. Lordship, in a recent case, similar case, Lordship, this High Court has also Lordship, if I may
allowed to place one order of this.
So your main ground is that district judge does not have power to
Yes, Lordship.
give
And it's
in.
been, held by this honorable court, legal petition 108 TBB.
Whether,
Which was recently passed on, 8/5 TBB. The copy. It's a similar case, Lordship. The contracts were seized. They see that they were smuggling some goods. And the additional district judge. Additional session judge, fast track, court number 3, Kanpur Metro, Gauhati, has ordered the release of the transaction. This court, in paragraph number 16, 16, 17, 18.
no, whether Caesar list indicates that Caesar was made under the provisions of,
Yes, Lordship. Then, the criminal petition clearly states, Lordship, that the seizure, all the things were done under the Customs Act only, Lordship. The state authorities were never involved. By seizing the goods, Lordship. And if the goods are also not even deposited in their mouth. It's with the customs only. So paragraph number 16 of the order, Lordship.
where is the power of Caesar?
Lordship.
Power of Caesar is 110.
110. Lordship. 110 of the act.
Okay, okay.
Under 110, the seizure can be done, and 110A, there's also provision for release of the goods, Lordship. And the burden of proof lies with the petitioner to show before the adjudicating authority, Lordship. However, in this case, they have not exhausted their applications remedy available to them under the act. And they have approached the sessions judge, whereby by jurisdictional error, order has been passed for releasing the goods.
Who defended you before the session judge?
There was one special counsel.
Yeah, he did not point it out.
However, it was not posted.
It was pointed out that session judge does not have.
Very wrong that releasing the so in similar cases, as I pointed out, in paragraph number 16 of the order,
Yes, please read.
this court is in agreement with the proposition of law that when section 110 of the Customs Act especially provides for that the proper officer will be empowered to take a decision on the prayer of release of seized goods to the owner, and alternative approach to a criminal code under the provision of section 497 of the PA and would not be called for. This is so because the Customs Act is a special legislation where the provision of the NSS 1523 deals with general law. This court also notice that it is not the case of the respondent that any violation of the provision of the Customs Act 1962 before the additional session judge while praying for the release of the vehicle, which was seized under the provision of the Customs Act. The reference of the other court to the decision rendered by the court in so appears to be misplaced in the context of the case at hand, in as much as the aforesaid case had referred to the procedure of custody and disposal of valuable articles under the Criminal Procedure Code 1973, but had not held that the provision of the CRPC would prevail over the provisions of the Customs Act 1962. Insofar as the power to execute
prayers for custody and release of the vehicle seized under the provision of the Custom Act where constrained. This court finds useful reference to an earlier decision of this court rendered to Division Court 2003 in the case of Union of India versus Tununga and another in criminal revision petition number 1 of 2023, where it was held as follows. It cannot be disputed that articles which come under the domain of the smuggled goods are within the authority of the customs department, which deals with the same as per the customs, which is a special act, and section 5 of the CRPC provides that provision in CRPC will not come into clash with any special or local law for the time being enforced. It would be convenient for section 5 of CRPC as per nothing contained in this act in the absence of specific provision to the contrary affect any special or local law for the time being enforced or any special jurisdiction of our comfort to any special form of procedure prescribed by any other law for the time being enforced. Your Worship, the order passed by the learned session judge is without authority. That's why this criminal petition have a question the same order.
But then, okay, this is on the merit of this case.
Yes.
That I will hear the other side. But what is your response? That you have not complied with the order?
94 gives for the
Yes. Yes.
If I may, Your Worship. Your Worship. Learned CGC that will be notice on behalf of President 1 and petitioner shall take steps for service support to by any force as well as usual process which should be this paragraph that in the this directed the respondent authority shall release the 570 facts of articles to the petitioner, which has already been released by the school state and session just by coordinator 203 units. So basically what they order about by the session chair, they drew order to pass. And Your Worship, the other party has not been heard. And the there was misjoinder of party also, non-joinder of this three party, that is the customs office. So the opportunity was also given to her, and after the contempt was filed, the customs officers have been included, and I was awaiting instructions in regard to the steps taken by the customs. However, the criminal, the order passed by the learned sessions judge, it has to be interfered with.
What is WPC 117?
117 Your Worship. Here also the petitioner has challenged the extension of show cause notice. The time period for issuing show cause notice to the person of the goods is 6 months production, which can be extended by another 6 months. While the procedure is in question, the investigation has been stayed. Now that also we are in the process of challenging that also. Because the investigation itself has been stayed by us. So we are under process, Your Worship, for filing the necessary application. However, the criminal petition can be disposed of.
Yes, on criminal petition.
I think, sir.
But we have to segregate.
This is arising out of the seizure of the record. So can we?
No, Mr. Zamir. We have to decide what to decide first. So His submission is that the criminal petition should be disposed of first because it challenges the order passed by the district judge on some ground, technical ground. And the writ petition should be decided on its own merits.
Yes.
So we are hearing,
That the procedures prescribed under the law. I cannot say that no, that is correct. But what I'm trying to draw the attention of this honorable court is how these all problems have been started. It started from the seizure of the articles. And what type of articles have been seized by the custom authorities. That is why I was trying to draw the lordship's attention to the WPC number 42 of 2026, that is the first petition, where we have imposed
by the adjudicating authorities.
I have imposed the serial memo. In the serial memo, it is shown that brownish colored tribe arecanut believed to be of foreign origin. So, on that suspicion, they have seized the articles believed to be of foreign origin. In fact, it is of foreign origin. Which foreign country permits origin arecanut? We are not disputing that. In fact, it is permissive origin arecanut seized by government of Manipur.
and lawfully auctioned.
Yes, kindly come to page 23. I'm referring to WBC 42 of page 26. Do you think that it is a rich smokable item directly in contravention of the law? That is how they have seized. But kindly come to page 23 of WBC 42 of page 26. Page 23, this is the type copy of the order. It is about auction. Page 23. Was done in first October 2024.
Yes.
The highest paid amount offered by Sri Muhammad Alauddin, proprietor of Zamzam Traders, in respect of the following seized and confiscated premise origin non-eatable supari. Like and so in public auction sale held on 14/10/2024, and then it was approved. So
What do you do with non-edible suparis?
it can be utilized in the factories for dyeing purpose and what.
On dying, okay.
It is non-eatable also. And the respondents are trying to show that we have sent to forensic laboratory for examination of food. That may be relevant in context of eatable supari, because it will be harmful for human consumption.
Yes,
But
it is admittedly non-edible.
Yes. Non-eatable, promise origin. And the seizure, the object of seizure is, it is suspected to be of foreign origin. At one point of time, it was a contraband item. Now it is certified by way of a public auction. And then from there, by a government, not by private. And we have purchased, and then a agreement was entered into, and then kindly see the transit pass. Transit pass, e-transit pass has been issued by the government of Manipur. And thereafter, the government of Nagaland at page 56. Page 56. Was on 18 December 2025. It is, particulars are shown in the transit pass. And then up to the seizure on 20th December, some clarification was made. So kindly come to page 61. Clarification was made by the divisional forest officer regarding the transit pass, and then this transit pass is valid. And thereafter, can we come to page 65? Really, everything we have paid as per the guidelines.
Okay, what was your case before the writ court?
Now, my learned friend has submitted lot of provisions with regard to the technical infirmities in conducting the criminal case by the civil judge. Once it goes also, the order passed by the Honorable Court is valid, which was passed on 9/4/2026. This Honorable Court may pass by relying on some judgment, by referring to some judgment, or it can pass on its own. Therefore, just because a reference was made on the order passed by the civil judge, this Honorable Court has the power to pass order, so accordingly it was passed. And then thereafter, the contempt was filed for non-complying to this Honorable Court's order. Can you come to a contempt project just for a minute? COP 15 of 2026. COP 15 of 2026. Order dated 27/2026. That is the last order passed by this Honorable Court.
Yes,
Has the lordship read it?
yes.
But the learned senior counsel, city chairman for the petitioner, assisted by so and so. The learned counsel for the respondent, Z. Konun, has already filed Baglatnama on behalf of respondent number 3, Shri so and so. The learned counsel for the respondent also prays for 2 weeks' time to file affidavit of compliance in the instant case. So that was on 27/2026. They have to file the compliance application affidavit. Considering the fact that the interim order of this court was passed on 9/4/2026, and the respondent is yet to comply with the said direction of this Honorable Court, this court. It is made clear that on the next date of listing, the respondent shall show compliance of the direction of this court, that is today. And they have not shown anything. Criminal proceeding is one aspect, and the order passed in the proceeding in WBC number 42 of 2026, and the contempt petition of 15/2026 are one part.
Yes.
And if no action is taken on the respondent, it will amount to ignoring the order passed by the Honorable Court. It is will be acknowledged. Tomorrow public may come and say that no, even if the High Court passed order, we can do this, do that. The order passed by the Honorable Court.
Yes, no, that will be decided.
It time to challenge the order also, but they have not taken that steps. Their sole objective is to delay the release of the items so that in the process it will be damaged. That is the sole objective. What benefit really came by withholding the seal certificates?
He replies.
Lordship, I want to place one judgment. If they have 6 articles with this under suspicion, there should be sufficient materials to show that it is suspected to be of that. They are saying it is some foreign origin. Admittedly, it is of foreign origin initially, and then it was sold on an auction, and then that was transported. So what is shown here? What offense we have committed? And the valid transit pass we have transported. And the order has been passed by the Honorable Court.
No, what is your response regarding content?
Since 2-3 departments, that's why there's.
Whether- No, whether parties have appeared in
Yes,
writ petition, appearance is complete.
appearance is complete. I have received the powers to grant in.
You have not filed any of,
Yes, Lordship. It's not yet filed, but I have received the instructions there, which I'll be valid and for.
but you have not complied with the interim order, neither you have filed any appeal against him.
Not yet.
Either you have to comply or
Yes, Lordship.
you have to file an appeal.
We are-
Even if,
we are- we
even if,
are- this one.
even if the order of session court goes,
Yes,
the order of London, the coordinate
Yes.
bench
yes.
of this court remains.
So
So you
we
have,
are- We are going to file an application for it, under 226(3). Lordship. It's there, but it's not yet ready. That's why sometime will be granted. However, the criminal petition can be disposed of.
yes,
It is possible.
criminal petition we are disposing of.
But already 4 months have lapsed after the order passed by this honorable. 94. It's already 4 months will be complete.
Just 2 weeks time. Lordship.
Criminal
Yeah, it
petition,
can be sufficient time.
in criminal petition,
May I please, Lordship? In the
Yes.
Criminal petition under 20. For the state.
oh yes, for this state, what is your submission?
My lord, you also made an only allowed to defer the section 497 of PNS's motion. Section 94 of P, that's 97 of P,
97,
97. Very good.
section only 97 or 497?
497. 497 of 497 plus 1.
Yes,
Very good.
yes,
Order for custody and disposal of property pending trial in certain cases. Clause 1. Any property is produced before any criminal court or the magistrate empowered to take cognizance or commit the case for trial during any investigation, inquiry or trial, the court or the magistrate may make such order as it thinks fit for the proper custody of such property pending the conclusions of investigation, inquiry or trial. And if the property is subject to speedy and natural decay, or if it is otherwise expedient so to do, the court or the magistrate may, after recording such evidence as it thinks necessary, order it to be sold or otherwise disposed of. So my lord.
okay, in this case, there is no FIR,
There is no.
only seizure list.
After this, your lordship, can you see the criminal petition page number 27? Criminal petition page number 27. Order passed by the session court. Page number 27, para. With the relevant person.
Yes,
Upon hearing the counsel and also perusal of the materials available on record, and the order of proceeding recorded by the learned chief judicial magistrate, white order dated 21/12/2025, it is seen that it has been clearly recorded that complaint report filed under section 7, clause 111, 104, 1110, 1112, and 35 of Custom Act 1963 was received from the senior intelligence officer, ERI, Dimapur Regional Unit against the accused person, and along with the said complaint, 2 arrested accused persons were reduced and were remanded to judicial remand for 15 days. It may also be noted here in that complaint was registered as GR 718/2025. It is also pertinent to mention here that the CGM has wide its order dated 21/2026 have enlarged the 2 accused person on there. Thus, from the above materials available on report, the regular court is seized of the complaint and has accordingly take cognizance of the case or offense. My lord, here complaint was not reported at the session court and the before the criminal court, and the cognizance was taken by the their cognition was taken.
no, but whether the regular court has jurisdiction
Your Worship, yes, matter. Section one of the BNSS, where OTP is produced before any criminal. So no OTP was produced before the court. It used to the custodian and further, as per the, section 104. The persons arrested, we do not have, our own jail, so we have produced those arrested person before the registration.
And that is the requirement of Customs
Yes.
Act.
That is the.
But the adjudicatory authority,
Yes, my lord, in the statement clearly says that complaint was received by the magistrate, by the criminal court.
no, but criminal court does not have jurisdiction.
My humble submission is, since the criminal court has received the complaint, taken conclusion, that is why under section 497, that this order was success. That is my humble submission.
No, whether a regular criminal court has jurisdiction to adjudicate the no, as regards offenses, offenses can be tried only by a criminal court. Only as regards confiscation and penalty, the Customs Department. So the jurisdiction of criminal courts is not, does not, I doubt.
Means here, approval was exceeded every time, provisional release here. The order of also as per the special actions. Everything is.
But here Caesar has been made in respect of an criminal case.
So, on the, seizure was done under the seizure case of the customs.
But in respect of the said Caesar, a criminal case was also filed.
The persons were.
Not only because of that, but because of filing of a complaint where you have alleged commission of certain offenses.
Bail and all those.
Not bail, then the question is whether the jurisdiction of,
That's why, under 497, when it's not produced before the criminal court. The systems were not produced before. So the magistrate is not empowered. The two persons, the drivers of the vehicle, they were arrested and produced before the magistrate. So the magistrate has passed the order for releasing, we are not alleging that. However, the goods were never produced before the criminal court. So the magistrate or the district judge does not, session judge does not have the power to release such goods. It's clear from the section itself.
okay, heard Mr. Z. Kulnu in criminal petition numbers. Z. Kulnu, learned standing counsel, DRI,
CBIC,
CB,
customs, all those indirect taxes.
CB,
CBI, Control Board of Indirect Taxes and Customs. Indirect Taxes and Customs.
learned standing counsel, Central Board of Indirect Taxes and Customs, within bracket CBIC. Also heard Mr. C.T. Zamir, learned senior counsel, assisted by Mr. Aliba Kozukam, learned counsel for respondent number 2, as well as Mr. E. Tibafom, learned government counsel appearing for the state of Nagaland / respondent number 1. This, next para, this application under section 528 of BNSS 2024 has been filed by the petitioners praying for setting aside the order dated 12/3/2026 passed by the Court of Learned Principal District and Session Judge / Special Judge Dimapur, Nagaland, in connection with DRI Caesar case number 02 capital CL /IMP /ARECA /DRI /DIRU /2025-2026. Dated corresponding to GR case number 718/2025, whereby it had directed release of s- 570 bags of Areca nuts seized by the Customs Department to the respondent number 1 on furnishing of a bond of rupees 10 lakhs along with a surety of like surety of along with a surety to yes, surety to the satisfaction of the investigating officer of the case. The facts the facts relevant for next para. The facts relevant for consideration of the instant criminal petition in brief are that the that on 19/12/2025 on receipt of an information through reliable sources by the officers of Directorate of Revenue Intelligence, Dimapur, to the effect that some trucks are carrying smuggled foreign origin areca nuts from Manipur to Dimapur during the early hours of Dimapur and would likely to reach Dimapur during the early hours of 2012-2025. A surveillance team was arranged at the National Highway at Uki Dolong on National Highway leading towards Dimapur stop. After some time, that is around 7 hours on 20, that is at around 7 hours on 2012-2025, two trucks bearing registration number CG04JD 5709 and AS01FC 7638 were intercepted by the customs officials, by the DRI officials at Kukidolong. During interrogation of the drivers of the said truck, it was informed that said trucks were carrying areca nuts loaded from Ukhrul district, Manipur, for delivery at Dimapur in Nagaland. Stop. During search of the said truck, it was found the said trucks were carrying 570 bags of areca nuts, weighing around 45,600 kilograms, with an approximate value of rupees 3 crore 90 lakhs 52,376. Stop. On further interrogation, the drivers of the said truck produced the transit pass purportedly issued by Forest Department Fake Division, Government of Nagaland. However, during examination of the said transit pass, it was found that the transit pass pertains to only 25,000 kilograms of areca nuts, whereas actual areca nuts which was recovered therefrom was 45,600 kgs. Thereafter, suspecting the recovered areca nuts to be smuggled and of foreign origin, which is liable to confiscation under provisions of the Customs Act 1962. The said Hurricane, along with the trucks carrying the same, as well as other items and documents recovered therefrom, were seized under section 110 of the Customs Act 1962. Stop. It was also alleged that the person arrested were liable to be punished under section 135 of the Customs Act 1962. As such, they were arrested. Stop. Thereafter, next paragraph. Thereafter, investigation under Customs Act 1962 was initiated. And what is notice under 124?
Under section 110A, customs authority has the power to release the goods within 6 months. But since the period of 6 months has already elapsed, so you will have no authority. That's why a show cause notice has been issued, extension of the notice was issued under section 124. That was challenged in the subsequent.
124 is the show cause notice to the owner of the goods for by the authority of law. Issue of show cause notice before confiscation of goods is occurred.
Okay. Notice has been issued, no.
Oh, okay. The investigation is still under.
It is further stated in the criminal petition that the notice, show cause notice under section 124 of the Customs Act 1962 is yet to be issued. However, in the meanwhile, the respondent number 1 approached the Court of Learned Principal District and Session Judge, comes Special Judge Dimapur, claiming ownership of the seized areca nuts and praying for releasing the same to him on furnishing of after preparation of Jimanama. Accordingly, by order dated 12/3, impugn order is 12/3. Order dated 12/3/2026, passed by the learned District and Session Judge, comes Special Judge Dimapur in GR case number. GR case number 718/2025. The respondent number 1 was granted Jimma of the seized Areca nut on furnishing of a bond of rupees 10,000, 10 lakhs, as well as furnishing of security to the satisfaction of the investigating officer. The aforesaid order has been impugned in this instant criminal petition. Next para. Mr. Z. Kulnu, London, Standing Counsel. What is the CBIC? CBIC, Understanding Council CBIC, has submitted that the learned Principal Session Judge cum Special Judge Dimapur has erred in passing the impugned order by granting the Jimma of the seized Areca nut to the respondent number 1 without having any jurisdiction to do so under the Customs Act 1962. He submits that the Customs Act, the provisions of Customs Act 1962 being a special act would prevail over the provisions of the General Act like BNSS 2023. He submits that the seizure of Areca nut in the instant case has been made under section made by the custom authorities in exercise of powers under section 110 of the said act. He further submits that the he further submits that under section 110 within bracket 1A, capital 1A of the said act, the power to dispose of the goods seized under section 110 of the act in case such goods are perishable in nature or hazardous in nature is with the proper officer where proper officer has been defined.
DKT is the under section 122 for purpose.
Proper officer under the meaning of this said no क्या लिखा
initial authorized relations between officer and the meaning of the same.
With the proper officer. Stop. He submits that the proper officer in the instant case would be an officer who has power to adjudicate the matter regarding confiscation and imposition of penalty under section 122 of the said act, who in the instant case would be Commissioner of Customs. He submits that under such circumstances, the order passed by the London Principal District and Session Judge cum Special Judge Dimapur, granting Jimma of the Areca nuts to the respondent number 1 is beyond jurisdiction. In support of his submission, he has cited a ruling of a coordinate bench of this court in the case of Union of India versus Syed Ali Laskar, within bracket, judgment dated 8/5/2026 in criminal petition number 1086/2025. Stop. He further submits that though in respect of the said seized areca nuts, an order has also been passed for releasing the same by a coordinate bench of this court. On which date the order? On 9/4/2025 in WPC number 42/2025. 2026.
So case number is 2026.
9/4/2026
Yes. Yes.
in WPC number 42/2026, and a contempt case has also been filed by the respondent number. No, and a contempt case has also been filed in that regard, which has been registered as COP within bracket C number 15/2026. However, the present petitioners are intending to file an application under Article 226 Clause 3 for modification of the interim order before in the said writ petition. Stop. On the other hand, next para, on the other hand, Mr. C.T. Zamir, the learned senior counsel, appearing for the respondent number 2, has submitted that the present petitioner has purchased the seized areca nut from its owner, namely Messrs. Jam Enterprise, who had purchased the said areca nuts in an auction conducted by the government of Manipur. In a public auction conducted by the government of Manipur. He further submits that after purchasing the seized areca nut from the
Traders.
from the its owner, namely Jam Traders, the said areca nuts were transported from Manipur to Dimapur with proper transit passes of issued by both government of Manipur as well as government of Nagaland. He submits that the where is that option?
23
Of your writ petition.
is of valid petition, WBC 42 of 2026. This patent items are premise origin, 9 liquidable supply. Page 23. That is the table.
He submits that the order dated 31/10/2024 of the Government of Manipur from Office of the Chief Conservator of Forests / Territorial -2 Imphal itself indicate that the seized areca nut which were purchased by the present petitioners from the proprietor of Messrs. Jam Traders were earlier seized and confiscated and were reportedly of Burmese origin, non-edible supari, and it is only after confiscation the public auction was conducted. Learned Senior Counsel for the petitioners, for the respondent number one or two submits that since the respondent number two has purchased the said supari from the lawful owner who had purchased the same in a public auction conducted by Government of Manipur after seizure and confiscation of said suparis. No offense may be attributed to the present respondent number two. He further submits that as in connection with the present seizure for the second time after the said consignment of said Burmese supari was in transit to Dimapur. Since a GR case was also registered, is it also your submission that he has jurisdiction? Session.
So, sir, in view of the registration of the case as GR.
GR case, the session judge, cum special judge Dimapur, was well within its power to release the seized, well within its power to direct release of the seized areca nut on furnishing of a bond and subject to production of sureties. Stop. He further submits that when, in spite of the direction of the session judge, which has been impugned in this criminal petition, the areca nuts were not released by the respondent authorities. You have approached filed a writ petition or somebody else? 42? You are not the petitioner. 42 is some association seems to be petitioner.
That is the name of the firm. Nagaland Alligator Traders Association.
It is some association.
Nagaland Alligator Traders and Transport. This is the name of the firm.
Your firm.
Name of the firm.
Okay.
Nagaland Alligator Traders and Transport.
Okay.
Trade license is also in page number 20.
Yeah, likha last.
It is not released by this respondent.
Comma, the petitioner, no, the respondent number 2 approached this court by filing a writ petition. Which was registered as WPC number 42/2026. He submits that in the said writ petition by order dated 9/4/2026, a coordinate bench of this court had directed the respondent authorities to release the seized 570 bags of areca nuts to the respondent number 2, to the present respondent number 2, immediately. Stop.
They have received the order of this honorable court on 10/4/2026.
He further submits that the said order has been received by the respondents on 10/4/2026. However, in spite of the same,
Here, the receipt by respondent number 1 and 2, who are the investigating authorities, not the adjudicating authority. The order was first received. Some department. No, Your Worship, different fact. The rules
Under customs only.
one is investigating, Your Worship.
received by whom?
Investigating is done by.
The respondent number
1 and 2.
in that petition.
Yes, the release of goods has to be done by respondent, but she will later on be.
Received by respondent number 1 and 2 on 10/4. What was the last line? However, when in spite of the direction of this court, the areca nuts were not released by the respondent authorities, the petitioner was compelled to file a contempt case, which was registered as COP within bracket civil 15/2026.
This order in the contempt is 27/2026.
He submits that in the said contempt case, the respondents were directed by the court on 27/2026 to show compliance of the direction issued by by the court on 9/4/2026. Stop. He submits that, however, the areca nuts are not yet, areca nuts are yet to be released. He further submits that areca nuts, seized areca nuts, being perishable goods, are required to be released in terms of the orders of the learned session judge, come Special Judge Dimapur, passed on 12/3/2025, 26, as well as also in pursuant to the direction of this court, passed on 9/4/2026. He therefore submits that this criminal petition is liable to be dismissed.
The judgment which Leonard Penn has referred to is another facts.
He also submits that
It's not applicable to
the
this.
facts of the ruling cited by Learned Council, Learned Standing Council, CGIC, CBIC are distinguishable from the facts of this case, and as such, same is not applicable. Hence, he prays for dismissing the instant criminal petition. Stop. Next para. On the other hand, Mr. E. Tiba Form, the learned counsel for the petitioner, learned counsel for the state respondents, number 1, has submitted that there is no infirmity. Your crux of your submission is that session judge has jurisdiction and there is no infirmity in the impugn order. There is no infirmity in the impugn order passed by the learned session judge cum special judge Nagaland in GR case number 718/2025. He submits that since on the basis of a complaint filed by, where is the complaint? Yes, complaint filed by the DRI Dimapur before the Court of Learned Chief Judicial Magistrate Dimapur under section 7 within bracket 1/11/104/1110/1112/35 of the Customs Act 1962. And on the basis of the said complaint, the GR case number 718/2025 has been registered. The criminal court, including the Court of Learned Session Judge, does have jurisdiction to dispose of the property seized during the pendency of the investigation of the case under section 497 of BNSS. He therefore submits that no interference is justified in the impugn order passed by the learned session judge, and same is liable to be dismissed. I have to go through this judgment. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also considered the submission ruling cited by learned counsel for both sides in support of their respective submission. Stop. This item number. Stop. Though today this criminal petition is clubbed with writ petition number 42/2026 and writ petition number 117/2026, as well as COP within bracket C number 15/2026. For the sake of convenience, this court is inclined to dispose of the instant criminal petition first and thereafter consider the writ petition on some other day. Dot. Separate order. Separate order. No, this will be in criminal petition. Heard so and so, hearing concluded, judgment reserved. In writ petition, in contempt petition, a separate order. Right in item number 7. Item number 7. Heard Mr. C.T. Zamir, learned senior counsel, assisted by Ms. Aliba Ozukam, the learned counsel for the petitioner, as well as Mr. Z. Kulnu, appearing for respondent number, all the respondents. What is your submission? If you were directed to,
I would be allowed some time to have my objection. Or it's under preparation.
Can they see the last order?
Yes, yes.
Relax.
Yes.
That would be found soon. It's already.
Yeah, respondent, stop. Learned counsel for the petitioner has pointed out that by order dated 27/2026, the respondents were directed to show compliance of the directions of this court. However, today also they have failed to comply with the same. On this, learned counsel for the respondent has prayed for some time for filing written objection. Stop.
Last occasion, the submission was to file the compliance affidavit.
Written objection, stop. Though it appears that on 27/2026, the learned counsel for the respondents sought time from this court to file affidavit in compliance. However, it appears that the respondents are taking a contradictory approach and seeking leave to file written objection in the sent complaint petition. However,
How you can they can ask to have directed to file the compliance affidavit. I was directed. So.
no, before that, you made prayer
That I'll be filing.
compliance,
Affidavit.
affidavit in compliance. That is what is written in the order.
Pending petition to file objection against the order passed by the Senate court.
That's really because the respondent number three was withdrawn in the. So I was received some direction to appear before this court. And I was looking instructions, so I saw some time.
Yeah, Likha. However, considering the fact that in a connected matter, that is criminal petition number 18/2026, both the parties were finally heard and the matter is reserved for delivery of judgment. Some time is granted to the
Short till you be given the total time is. Granted by the Senate court. within 4 months.
respondent to report compliance / stop. To report compliance / file return objection. Stop. Let this matter be listed next Thursday.
That is 13.
13th,
I will not be there on 13, 12 and 13 and
14th,
14 is.
on 14th. On 14th. List accordingly. In repeat now.
This item will be kindly considered tomorrow.
Just a minute. In read petitions also, 8 and 9. In read petition, appearance is complete. You'll be filing any affidavit in opposition. Will you be filing of affidavit?
Yes. In, if you see for people I have my opposition on behalf of particular
117 they have not filed.
So 42 is ready for hearing.
Yes, no, because, follow number 3 is here. A response.
Okay. In 42, heard Mr. C.T. Zamir. Same likhna.
Assembly.
Also heard Mr. Z. Kulnu appearing for respondent number 1, 2, and 3, as well as Mr. E. Tibafom. Okay. Respondent number 1, 2, and 3. It is submitted by learned counsel for the respondents that though respondent number 1 and 2 have filed their written objection, however, filed their affidavit in opposition. However, some time is sought for filing of affidavit in opposition by respondent number 3. The prayer is allowed. Let this matter be listed on 14th. And in WPC 117.
And yes, another respondent number 2 is another.
Your party in 117 also same order. Not same order. The learned counsel for the respondent sought time to file written of affidavit in opposition. Prayer is allowed. Let this matter be listed on 14th of.
One matter, urgent matter is to be listed tomorrow. I filed it yesterday.
What is the matter?
This is regarding, we are challenging a show cause for this. If,
Okay, allowed.
no order is passed, then there is chances of terminating the license.
Okay, allowed.
Any other question?
Rishi. This petition, along with these citations, will take hold. And though the order for segregating the petitions have been passed, for now, it has to take time.
Orders item number 23.
My lords, I'm appearing
as an applicant in item number 23, my lord. My lord, I have filed an impleadment in the contempt only to assist this honorable court and bring the factual position as on that, which my appeal has been earlier, which has been restored, has been withdrawn, has been restored. And then it is pending for hearing admission on 18th of September 2026, my lord.
Item number 22 or 3?
23, my lord.
There is a big, it's where I have come across. The 5 petitioners whose petition were dismissed by the Supreme Court. It came back to division bench of the Honorable Gauhati High Court for review. Now, as per this order dated 23/7/2026, they have already withdrawn it. Now, what has happened is in this contempt case, not even in the petition, in a contempt case, they are asking this honorable court to implead them as contemners. As
Contemners.
contemners.
My lord, all I'm praying before this honorable court is to assist this honorable court and bring the factual position as on that. My lord, my learned counsel has submitted about the withdrawal, which is incorrect to some extent because we have filed an IA, because the honorable division bench, the chief court has directed us to file an IA, and in that IA, if I may be allowed to share the screen, my lord, I can take you to the order that was passed in an IA. IA number?
No, contempt petition has been. No, the contempt petition has been filed alleging contempt of which order?
Of the single bench judgment and order 28th of September 2024, which I was arraigned as a respondent. Therefore, Lord, my lord, now any point of time, if the government takes the steps, it will affect my service, it will affect my rights. Now the appeal which I have withdrawn in 2026, vide order 23rd of October 2025.
But one more. Your
Yes, my
name
lord.
is Mr.
K. Luikang Michael, my lord.
Michael.
Yes, my lord. Michael, my lord.
K. Luikang Michael. Mr. Michael, you are
Yes,
not the person who has to comply with the order of the court.
Correct, my lord. I agree. But I lord,
You
my
are,
lord,
you are not the contemptor.
agreed, my lord.
Yeah, sir.
In the contempt petition, we will not go into merit again. We will only see whether the order of the court has been complied with or not. Only that much. If it is not complied with, the contemptor will be liable for punishment.
Exactly.
That is the only jurisdiction of this court. We cannot go into merits, and so your presence is not required because we will not go into merits in a contempt case.
I bother, my lord. My lord, the factual positions are not brought to this honorable court. Therefore, I just only want to assist this honorable court. As an officer of the court, I want to assist this honorable court and bring factual facts. As on that, if my lord allowed me to share the screen, there is already an order passed in another IA, which the honorable division bench has directed me to file it. And then the matter was taken up on 23rd itself.
Where is the law? Where is the law? Learned counsel. In a contempt proceeding, how can a petitioner become contemptor? Don't underestimate the authority of this honorable court. Where is the law? Give the law. Never come across this kind of religious petition. And they are extending it to file.
My lord, allow me to share the screen. I can take you to the order that has passed in an IA, my lord.
Allow me to submit that they are doing all this in order to delay tactics. Because this honorable court, the Advocate General Lordship, he has appeared before this honorable court, and by 1st September, they have placed on oath, has stated that advertisement will be made by the end of this August. And This honorable court has fixed the matter on 1st September to be listed
What is this
for
review,
compliance.
review petition?
Review petition, they have withdrawn it again. In
My
the
lord,
list of days.
the
Now they are
honorable court
saying that
directed
they are
us
not
to
like
issue
they
the
were
review
looking
petition
for
and
right
file an
now.
IA.
That's why even the Supreme Court has already dismissed it. Now, Lordship, they are doing all these
My lord,
things.
I have a intra court appeals
to
provision.
make the implementation of
No.
the judgment of the law.
But in a contempt case,
Exactly.
you are not the contemner.
Exactly.
You don't have to comply anything. Compliance is sought for from the government side.
Government side.
From the government side, my lord, I only want to assist this honorable court and bring the factual positions.
No assistance is required in contempt matter.
I leave it to my lord.
Heard. Mr. K. Louis Kang Michael, learned counsel for the applicant. This interlocutory application has been filed in connection with the contempt petition bearing number COP within bracket C 16/2025, whereby the present petitioners, present applicants have prayed for pleading them in the present contempt proceeding as any order passed in the contempt proceeding as any order passed in this contempt proceeding will affect the rights of the present applicant. It is submitted by learned counsel for the applicant that present applicants were the private respondents in the writ petition number. Your respondents or PT?
Yes, my lord. In the writ petition 189 to 199 of 2022, which has been disposed of, Friday order, judgment order 20 of November, September 2024.
WPC number 189 to 199 of 2022. Learned counsel for the applicants further submits that as rights of the applicants are going to be affected and as they are also inclined to assist this court on bringing factual aspect before this court, they may be pleaded as the respondent in the connected content petition. On the other hand, Ms. Z. Zimomi, the learned counsel for the contempt petitioner, has submitted that this contempt petition has been filed due to failure on the part of the state respondents to comply with the directions issued to them by the court in WPC number 189/2022 and other analogous writ petitions. She submits that the contempt case, in the contempt case, jurisdiction of this court is very limited. And the court has to see whether the contemner is liable to be punished for non-compliance of the court's order. It cannot again reopen the issues which has already been determined by the court in the writ proceedings. As such, the prayer of the applicant in this interlocutory application is uncalled for and should be dismissed. Mr. Inti Misong, learned additional AG, submits. What is it? You have any submission? Has submits that he leaves it to the court to decide the instant interlocutory application. So after going through the materials available on record, this court is agreeable to the submissions made by learned counsel for the contempt petitioner, Ms. Z. Simumi, that the jurisdiction of a contempt court is limited to ascertaining as to whether the contemner is liable to be punished in terms of the Contempt Act and other relevant provisions for non-compliance of the court's order. It need not to look beyond the order which is said to be disobeyed by the contemner. Stop. As such, this interlocutory application does not have any merit and accordingly dismissed. The prayer for implement of the applicants as contemner in the connected contempt case is hereby rejected. What happened in contempt case? In main contempt case?
Lordship, it has been made since only because we filed the alia, otherwise all the petitions are fixed on first. So the name is
Only IA has been listed.
for years.
One submission, my lord. If my lord can reflect that my appeal has been restored and then is pending for admission on 18th of September 2020, I'll be really grateful, my lord. If that can be incorporated in the order. I can share you my screen, my lord.
No.
What does it got to do with present?
No further observation.
Obliged, my lord.
Obliged.
For hearing item number 24.
Mr. Sheki, we don't have much time.
Yes, Your Lordship.
Item number?
24. Since I know the respondent would be listening to what my learned brother, my learned friend is very significant.
You want to start?
Lordship, I am for the applicant, Lordship. The petitioner, Lordship, the revisionist.
What is your submission?
Lordship. Lordship,
Ready?
Lordship,
where are you now?
I'm in Dimapur, Lordship.
Okay, will it be difficult on your part to travel to Kohima?
Lordship, due to the inclement weather, I was not able to travel today, Lordship.
We'll fix it on some other day.
Lordship.
Now, actually, time is also not much.
Yes, Lordship.
What is the issue involved?
The dispute raised by the revisionists in this case is that there was a civil suit filed by the revisionists before the learned district judge Zenegodo, the civil court Zenegodo, claiming that the road project did not cover the compensation which his client was due, that is the revisionist in lordship. Now, this is a project under the CRIF,
Under the CRIF, my lord, there is no provision for length compensation.
CRIF stand for?
Lordship, this is a central, the full form, my lord. Lordship, on file, this is a page 19 of my. My lord, this is Central Road and Infrastructure Fund. Act 2000.
There is a separate act.
Yes, your lordship, under this law, my lord, there is no provision for land compensation except only when it is a road which is a circle road of connected with the national highway. And my lord, there also the burden falls on the state respondents also, the state government, your lordship, to shoulder the responsibility. But in this case, a project under the CRIF, my lord, when there is no land compensation available, it is the petitioner, the revisionist, who did not want to part with his land, despite the fact that the village authorities of all the village lands which is within this road stretch, my lord, everybody agreed and NOC was issued. Accordingly, the contractor, he was awarded work by state as well as the central authority released the fund, and the PWT road and bridges, lordship, Nagaland, awarded the work to the respondent, who is my client, my lord, in this case. Now, my lord, on the claim of compensation, stating that his right of the property was not considered. If I was sued against the village authority.
His land has been taken for
Yeah,
construction of land.
Sir, his
No,
land-
but he has not been given anything in lieu of that.
Your lordship,
Yes, Lordship.
this case, yes.
Nothing
Yes,
has been
yes, your
given.
lordship.
Nothing, Lordship.
Your lordship, there was a decision taken by the village authorities, and that very decision says that the contractor will allow them to work in their portion of their land for like construction of the retaining walls for the nalas, your lordship. Everybody was given some privilege because the act itself does not provide for land compensation. All the others, they enjoy that benefit. But for the petitioner and a few of his cohorts, the lordship, instead of availing that opportunity, which was the only best solution next to compensation, because there is no provision for compensation, the lordship. Without availing all those, they just did not want to. Maybe there are some personal enmities which is not the concern of this own court, my lord.
Okay,
But they could have solved the issue amongst themselves.
it will take time. Nothing has been paid to the petitioner.
Lordship, if I may be able to submit, Lordship, just one line, Lordship.
Yes.
Lordship, it is not a disputed fact, Lordship, that the land, Lordship, belongs to us. The right, title, and interest is undisputed, Lordship. And Lordship, right,
Land
title, and interest is not.
already been utilized.
Yes, Lordship, it has been utilized, Lordship. It has been damaged, Lordship. Without my consent, Lordship, the no objection certificates were issued, Lordship. Without my consent, Lordship. Hence, this suit, Lordship.
But they did not participate in the meetings where they were invited also.
Suit was dismissed.
Lordship, the contractor, Lordship, the contractor has been struck off from the suit, Lordship.
Okay, against that you have.
Yes, against the impugned order, Lordship, I am here, Lordship.
Then issue
Otherwise-
is very big issue.
Otherwise, it is pending in Zinevoto, Lordship.
Okay, we'll take it up on some other day. Today we.
Lordship, if we can come up tomorrow, Lordship, if that is possible. My senior, if he agrees to it, Lordship. Because this matter, Lordship, has been pending for quite some time, Lordship.
Okay.
Or any other date fixed by this Lordship.
Okay, we'll take it up tomorrow. If Mr. Sheikh is ready. Heard Ms. A. Nikato Wotsa, learned counsel for the petitioner. Also heard Mr. Joshua Sheki. learned counsel, for all the respondents?
So,
There are 4 respondents.
Your Lordship, for the respondent number 1.
Respondent number 1. Who is appearing for the other respondents?
The others are performer, Lordship.
Due to paucity of time, this matter could not be taken up for hearing today. List this matter again tomorrow. That is 7th of
7th.
August 2026.
Congratulations.
Item 24, huh?
Malo. Hello.